The hearing will come to order. I think Senator Lee is going to introduce our nominee. Is that right? He's on his way. But in the meantime, why don't we just go ahead and swear Ms. Rao in? Please stand. Please rise. Do you solemnly swear the testimony you give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. So chill out. Okay. Introduce your family.
Some remarks.
Lee's going to introduce her.
Thank you, Chairman Graham, Ranking Member Feinstein, and members of this committee for your consideration of my nomination. I thank the President for nominating me to be a judge on the D.C. Circuit Court of Appeals, and I am grateful to be here today. I just wanted to begin by introducing my family. With me here today is my husband, Alan Lefkowitz, and my two children, Isabella and Ezra. My family is, quite simply, my greatest joy. I'm also fortunate to be joined here today by my father, Dr. Jahangir Rao, and many members of my extended family. I'm grateful to so many friends who have come from far and near to be here to support me today. And at a moment such as this, I recall my mother, who passed away some 10 years ago. But I know that she is with us and in my heart, providing the good strength and counsel that she always did. I was born in Detroit, Michigan, to parents who had immigrated from India, coming to America in the early 1970s with their medical degrees and little else. They started with almost nothing, but through hard work, built successful medical practices and small businesses. My parents faced their share of difficulties, but they always emphasized the amazing opportunities in this country and the good people they befriended along the way. My parents raised me and my brother to be open-minded, and we had friends from all different walks of life. Through their words and actions, my parents reinforced goodness and kindness, the essential importance of family and friends, and the values of hard work, honesty, and integrity. I strive to live these values each day. I also cannot help but take notice of another funny coincidence, which is that Aditya Bomzai is a nominee on the next panel. My grandfather and Aditya's grandfather were the best of friends in India. And so today, Aditya and I, the two grandchildren of two old friends in India, are nominees at the same hearing of the Senate Judiciary Committee, only in America. So I consider it a great privilege to be nominated to this position. And as Alexander Hamilton explained in Federalist 78, uniform adherence to the rights of the Constitution and of individuals is indispensable in the courts of justice. If confirmed, I would adhere to the law and in each case strive for the good judgment required for the exercise of the judicial power. Thank you, Mr. Chairman.
Senator Lee.
Thank you so much, Mr. Chairman. I'm so sorry to Ms. Rao that I wasn't here to introduce her at the beginning. I had a conflicting committee assignment and rushed down here from that committee. I'm very pleased and honored to introduce our nominee for the D.C. Circuit, Naomi Rao. Ms. Rao is well known and is a distinguished scholar and prominent attorney across the country. Although she certainly has very big shoes to fill, having been nominated to fill Justice Kavanaugh's seat on the D.C. Circuit, I'm more than confident that she's up to the task. Ms. Rao is focused on administrative law for virtually her entire career, which happens to be excellent preparation for a nominee who is set to serve, if confirmed, on the U.S. Court of Appeals for the D.C. Circuit, whose docket is complex, it's dense, and it's vitally important to the development of administrative law in our system. She's currently the administrator for the Office of Information and Regulatory Affairs, which serves a very important role in our government as the clearinghouse for all executive branch regulations. She's also a law professor at the Antonin Scalia School of Law, where her scholarly work focuses on administrative law. In 2015, she founded the Center for the Study of the Administrative State, which focuses on, you guessed it, administrative law. She also served on the governing council of the American Bar Association's section of Administrative Law and Regulatory Practice, as well as on the Federalist Society's Regulatory Transparency Project. Before her life as a law professor, Ms. Rao served in the White House counsel's office and also served on this committee, on the Senate Judiciary Committee. She was a law clerk to two very distinguished jurists, Justice Thomas on the Supreme Court and Judge J. Harvey Wilkinson on the U.S. Court of Appeals for the Fourth Circuit. She's a graduate of the University of Chicago Law School, where she was on the law review, and she did her undergraduate studies at Yale College. She grew up in suburban Detroit, the daughter of two recent immigrants from India, and lives in Washington with her husband and her two children. Ms. Rao, welcome to the committee. We look forward to hearing from you and to hearing your answers to our questions. Thanks so much for being here.
Thank you, Senator Lee.
Thank you. Thank you, Senator Lee. My congratulations to the nomination, to your family. Thank you very much for attending. I know this is a big day in your professional and personal life. And with that, I will turn it over to Senator Feinstein for any statements you'd like to make.
Thanks very much, Mr. Chairman. As you have said this morning, we're going to consider 3 nominations, including the person before us, Naomi Rao, who is being considered for the United States Court of Appeals for the D.C. Circuit. I think most of us regard the D.C. Circuit as the most powerful appellate court in the country. And we find it true in part because the D.C. Circuit hears challenges of actions taken by the federal government. For example, most federal regulations, when challenged, are heard in the D.C. Circuit. This is of particular note since the nominee before us has spent the past several years leading the office that decides which regulations to implement and which to rescind. Writings that have specifically, since July of 2017, Ms. Rao has been in charge of the Office of Information and Regulatory Affairs. In this role, she has led the Trump administration's regulatory agenda, where she worked on repealing the Clean Power Plan regulation, repealing protections that address pay discrimination on the basis of race and gender, and weakening the CAFE standards bill that I authored with Senator Snowe. As noted, the D.C. Circuit hears most challenges to federal regulations. Thus, if confirmed, Ms. Rao could be in a position to decide cases about many of the very regulations that she has personally worked on. There's also been press coverage about a number of positions Ms. Rao has taken in her writings. While the writings that have received the most attention are from when she was in college, several are relevant to the work she has led at the Office of Information and Regulatory Affairs, and to cases she could well hear, if confirmed, to the D.C. Circuit. Ms. Rao has also expressed views on the unitary executive and on President Trump's ability to oversee Special Counsel Mueller's investigation and fire the special counsel. All these topics are important for this committee to examine. I have a number of questions for the nominee on her writings and her regulatory work, and I look forward to hearing from her and asking these questions. Thanks, Mr. Chairman.
Thank you very much. Your background, very impressive. You worked, you're a clerk for 2 judges, Justice Clarence Thomas, Supreme Court, and Justice Wilkinson on the 4th Court, who I know very well, 4th Circuit. You served as counsel to the Senate Judiciary Committee. Who'd you work for?
I worked for then Chairman Hatch.
Okay. And you served as Associate Counsel and Special Assistant President George W. Bush. What'd you do there?
Well, in the White House counsel's office, I oversaw a number of important legal issues in different agencies. I worked on judicial nominations and a variety of other issues.
What did you learn from your time as being a staff member of the Judiciary Committee?
I learned a great deal. I'm very, very pleased that I had the opportunity to spend about a year in Congress with this committee. I learned much more about the legislative process, how things work. I learned about how Congress takes seriously its obligation to make sure that statutes are constitutional. That was part of the role that I played there. And so I just learned about the whole legislative process and rulemaking and lawmaking here in Congress.
So you went to college at Yale, is that correct?
That's correct.
So tell us about some of the writings that you engaged in while you're at Yale. I think you know what I'm talking about. So
Much has
tell me what you were thinking then, and what do you think now?
Sure. Thank you. Thank you, Chairman Graham. When I was in college, it was a time of exploration. I spent a lot of my time at Yale studying political philosophy and reading social commentary. And perhaps like many of my colleagues and classmates at Yale, I enjoyed commenting on some of the narrow events that were happening at Yale. We were very focused on campus events. To be honest, looking back at some of those writings and rereading them, I cringe at some of the language that I used. And, I was young. It's over 2 decades ago now. But, I think I was responding to things that were happening on campus at that time. And in the intervening 2 decades, I like to think that I have matured as a thinker and writer and indeed as a person.
Well, specifically about the situation with the intoxication and sexual assault, can you explain to us sort of what you were thinking then and where you're at now?
Yeah.
Yes, Chairman Graham. So in some of my writings, I talked about the issue of rape and sexual assault, and I emphasized that rape and sexual assault are crimes for which men should be held accountable, and that no one should blame a victim of sexual assault or rape. I also attempted to make the common sense observation that there were some actions a woman could take to make it less likely to be a victim of those horrible crimes. And so that's what I was expressing in some of those pieces.
2013, you wrote a piece titled "The Trouble with Dignity and Rights of Recognition" about the DOMA debate. Could you tell us what your thinking was then?
Yes, that was about the Supreme Court's decision in Windsor, and one of the things I was writing about there was different conceptions of dignity. I've done scholarship on competing conceptions of dignity in constitutional law, both within the U.S. Supreme Court and in constitutional courts from other countries, and the Windsor case raised some particularly interesting questions about the use of the word dignity.
Well, you'll be going on. Have you ever been a judge before?
I have not.
So if approved by the Senate, you'll be on the D.C. Circuit Court of Appeals. What can you tell us about your ability to do that job, never having been a judge before?
Thank you, Chairman Graham. I think the experience that I've had over the past 20 or so years fits very well with the specialized docket of the D.C. Circuit, which, as was mentioned, hears a disproportionate number of cases about administrative law and challenges to agency action. I have extensive practical experience with those issues, currently as the administrator of OIRA, where I oversee regulatory policy in the executive branch, and as counsel for this committee, working in the White House counsel's office. I also have a lot of scholarly experience with the types of issues that arise, as I've spent over a decade studying constitutional law, administrative law, separation of powers, and the like. So I believe my practical and scholarly experience fits well with the responsibilities of that court.
And finally, you were chosen for your current position by President Trump to implement his agenda of trying to deregulate the country. Is that correct?
Yes, I was chosen to help implement the president's regulatory reform agenda, which is a very ambitious one, and I have sought to do that in my current position responsibly in a manner that's consistent with law and in ways that are transparent and promote the norms of due process and fair notice.
Thank you very much. Senator Feinstein.
Mr. Chairman, these are rounds of how long?
5 minutes.
5 minutes. Ms. Rao, let me get right to it. As administrator of the Office of Information and Regulatory Affairs, you, I think in your own words, and I quote, direct and oversee regulatory policy across the federal government, end quote. Given this role, if confirmed, will you commit to recusing yourself from all cases involving the Trump administration's regulatory actions? Yes or no would be fine.
Well, Senator, recusal is a very serious issue, and it's very important to maintain the impartiality and independence of the judiciary. And if I were to be confirmed, I would look carefully at the statutory standards for recusal under 28 U.S.C. 455. I would consult with my colleagues and follow the precedents and practices on the D.C. Circuit.
Okay. In 2007, Senator Snowe and I authored the 10 in 10 Fuel Economy Act. That's a national program. It sets fuel economy standards. These standards have already saved $65 billion in fuel costs for American families and 250 metric tons of carbon dioxide. Despite its success, the administration has proposed canceling the planned improvements in fuel economy and vehicle emissions for model years 2021 to 2026. You have highlighted this change as a focus of the administration. What benefit does eliminating the program provide to the American public?
Thank you, Ranking Member Feinstein. So it might be helpful just to explain my role at OIRA, which is that we coordinate regulatory policy. Of course, the primary policies are set by the relevant agencies. They're given the authority from Congress to implement regulatory policy, and that's what's been done with the proposed CAFE standards by EPA and the Department of Transportation. So those are rules that we have under review, and I think those agencies are seeking to implement the administration's agenda with respect to improving environmental outcomes and safety for the American people.
Well, is it true that your intent would have been to have canceled that policy from 2021 to 2026 when the real benefits come into play?
Well, Senator, it's, respectfully, it's not my intention, and currently the rule is in its proposed stage. We have not yet received the final rule from those agencies, so those agencies are taking into account all of the comments that have been received in the process. We believe that's a very important part of the regulatory process to hear from the public about the consequences of different regulations, and those will be taken account of in any final rule.
Well, just so you know, this was a very important bill, and worked a long time to get a bill that dealt with CAFE standards, which had not been touched in decades. And the first 10 years have gone by, and it has worked. And after the first 10 years, in the bill language, the administration must take the most cost-effective technical improvements and make them into their policies for the future. If followed, this would continue to increase fuel efficiency, and it would continue to save people money. I gather that in a speech before the American Bar Association on October 19th in 2017, you intimated that you might be opposed to this and take some action. I'm curious, are you opposed to this law?
Senator, as a judicial nominee or even as the administrator of OIRA, I'm not opposed to or in favor of any law. It's part of our responsibility to make sure the agencies are following the laws as enacted by Congress. And there are, of course, a number of laws that are relevant with respect to CAFE standards, and we are working closely with the agencies to make sure that they are following the law and regulating in a manner consistent with the statutes.
Thank you. One last question. Well, I think I'll let it go for now.
Take your time.
In September 2017, you withdrew a form developed by the Equal Employment Opportunity Commission, that's CEEOC, that sought to identify wage discrimination on the basis of race or gender by collecting wage data from some private employers. You have written that you withdrew the form because it was, and I quote, an extremely burdensome and not justified collection of information on wages. Question is, what evidence did you have to conclude that the form was too burdensome for companies to comply?
May I respond? Yes. So, thank you for the opportunity to clarify that. First, that decision is currently in pending litigation, so I am limited as to what I can say about it. But I did issue a stay of an expansion of the EEO-1 form, in part based on the standards under the Paperwork Reduction Act about information collections and the importance that they be minimally burdensome and have practical utility. Now, Again, but just to be clear, that's an interim decision. We stayed the form, and now it's up to the Equal Employment Opportunity Commission to decide whether to proceed with that form. And in the meantime, the existing wage and gender and race collections are still in place. So we're continuing to use the form that's been in place for a number of years.
And what would change that?
So at this stage, there's a decision that needs to be made by the EEOC about whether they wish to change the existing form and expand it in some way.
Thank you. Thank you, Mr. Chairman.
Senator Cornyn.
Ms. Rao, what is OIRA? I think it's the most powerful government agency nobody's heard of and few people understand. Would you take a few seconds here to explain what OIRA's role is?
Yes, thank you, Senator Cornyn. So OIRA is an office within OMB, and we are charged with reviewing regulatory policy around the executive branch. It's an office that's been in place since President Reagan, who issued an executive order creating the office, and we currently operate under an executive order put in place by President Clinton in the early 1990s. So the process at OIRA really is a bipartisan one that's now been around for a number of decades.
Would it be fair to characterize it as a clearinghouse?
It is a kind of clearinghouse. You know, agencies set the regulatory policy and they send it to us.
Well, to that point, does OIRA make policy
We do not. We do not. Congress gives that authority to the agencies.
So when it comes to the sort of legislation that Senator Feinstein was alluding to, would you be authorized to substitute your policy judgment for that of the agency guided by congressional statute?
I would not.
Ms. Rao, I've been reading in some of the Hill rags about your college writings, and I want to give you a chance to explain. You know, it's since Judge Kavanaugh's hearing, when we were taking a magnifying glass to his high school yearbook, it seems to be sort of the way things go around here now, that people go back 25, 30 years and look at things like that and try to criticize people for maybe some of their youthful indiscretions or opinions they expressed back then that are not particularly politically correct today. I know you've written about multiculturalism as an undergraduate student at Yale, and you expressed the hope that racial and gender differences would be appreciated and discussed, but you also wrote about your concerns that they be used to push for divisiveness and not togetherness. When I saw that, I was reminded of Arthur Schlesinger's great book, The Disuniting of America. And he wrote that it's important to learn much from other races, other cultures, and other continents, but that focusing too much on cultural differences can undermine the very idea of unifying American identity. Do you agree with him?
Well, Senator, I certainly have had similar experiences myself. I grew up in a very, diverse environment. I have friends from all different racial, ethnic, and religious backgrounds, and it's been my experience it's often hard to put a label or to categorize someone. And one of the things I was responding to at Yale was a push towards less tolerance and understanding. And I think perhaps I was idealistic and hoped that, especially in a small environment at Yale, we could have both the celebration of people's racial and ethnic differences, but also more unifying and more unifying and more unification and understanding.
Well, I hope this committee and this Congress isn't in the business of crushing youthful idealism or punishing people who exhibit that. So when Justice Kavanaugh was going through his confirmation hearing, when Justice Gorsuch was going through his for the Supreme Court, there was a lot of discussion about the Chevron doctrine. And as I understand it, it's a doctrine where the Supreme Court has said that they will defer to an agency's interpretation of their own authority to act in an area where Congress has been ambiguous. Is that correct? Roughly, please, well, let me put it this way, please correct me.
Well, so I think that that's partly the Chevron doctrine and also the view of the court in the City of Arlington case about agencies' ability to interpret its own jurisdiction. And those are precedents of the Supreme Court, which if I were confirmed, I would faithfully follow.
Well, you anticipated my next question. So is it the role of the D.C. Circuit Court of Appeals to overrule the United States Supreme Court?
It is not.
And it is the obligation of every judge on the D.C. Circuit to follow the precedent established by the Supreme Court of the United States, correct?
Yes, Senator, and I would do so.
Thank you very much.
Senator Leahy.
Chairman, I read that you, Ms. Rowell, you never tried a single case to verdict or judgment or final decision. Is that correct?
That is correct. My experience has primarily focused on government service and academia.
I understand that. I wonder, as some of us are a member of the D.C. Bar and, of course, Vermont Bar, various courts of appeals. Every time I've argued a case before a court of appeals, I've looked at judges who have tried cases, who have been involved in litigation before, because oftentimes the whole case revolves around what might have happened in the trial before. But 0% of your practice has been a lawyer in federal courts, correct?
You know,
Yes
Senator,
or no? I mean, that's an easy.
Well, I have worked with federal courts in my various government positions, and my private practice was in international arbitration.
So you tried cases in federal courts?
I have not tried a case, but I have worked on briefs and preparing others.
Have you tried cases in state courts?
I have not, because my primary experience has been as a scholar and working for this committee and for the executive branch.
Well, in the executive branch, have you had any of your practice been before administrative agencies?
Not directly before administrative agencies, but as the administrator of OIRA, I oversee administrative policy on a wide swath of issues from all the executive branch agencies.
Do you think do you understand why some may be concerned about somebody sitting on a federal court hearing appeals from cases that have been tried in federal courts, and that person has never tried a case in a federal court or a state court or a court of appeals? Do you understand why some can be concerned about that?
Yes, Senator. I certainly understand that concern. You know, there are a number of judges, you know, on the Court of Appeals who have had a similar background to mine that has combined academia and government service, especially for the Court of Appeals, where there are more purely legal issues that arise in those cases. And you know, the experience I've had is I think very germane to the specialized docket of the D.C.
Cases
Circuit.
I argue before courts of appeals, they may be legal issues, but it resulted from a trial.
Yes,
Those
of
came
course.
up, and you assume that the judges, no matter who had appointed them, that certainly those of us who are arguing the cases before it assumed that they had some idea what the courtroom was like. Now, you've made it your mission to deregulate government. I see it as making it harder for government agencies to use their authority to protect our health, our safety, and environment. If we had an administration that sometimes actually cared to address climate change, based on your past record, it's hard to see how you could give them a fair shot in court. For example, you wrote in the 1990s that climate change is nothing more than a major environmental boogeyman, and that the greenhouse effort is a controversial theory pushed by environmental groups. Do you still stand by those assertions?
You know, Senator Leahy, those are statements from college, as you said, a few decades old, when I think some of these issues were more hotly debated. And no, I mean, I think the science has become much more conclusive over time.
Conclusive in what way?
Well, I think you know, my understanding is that there's an overwhelming scientific consensus that there is climate change.
And do you agree with the overwhelming majority of scientists that say that climate change is not only an irrefutable reality, but it's been created by human activity.
Well, I believe there's also a lot of scientific evidence. My understanding is that human activity does contribute to climate change, yes.
Contributes.
Well, I'm not a scientist, Senator Leahy.
Now, in your college op-ed about date rape, you wrote, if a woman drinks to the point where she can no longer choose, well, getting to that point was part of her choice, implying that a drunk woman has no control of her actions, but a drunk man does, strips women of all moral responsibility. I prosecuted a lot of rape cases. I would hate to think that was the view of the courts and the juries. I do know this, that if that view is pushed, it results in victims too ashamed to come forward. And it could also result in juries excusing culpable defendants. Do you currently believe that if a woman consumes alcohol to the point where she can no longer consent, she's in part to blame for somebody who rapes her?
Senator Leahy, I appreciate the opportunity to clarify that. In that column, I make it very clear that rape is a terrible crime for which men should be held responsible, and no one should blame a victim of rape or sexual assault. I was trying to make, and perhaps not in the most elegant way, the sort of common sense observation that excessive drinking can lead to risky and dangerous behavior for both men and women. It's the advice my mother gave me. It's the advice that I give my children, and I certainly regret any implication of blaming the victim.
You can understand why that is there. I mean, why that implication, why people are concerned, that's what you were saying.
Oh, well, Senator Leahy, the context of the column was a particular event on campus, and I'm also make a number of statements very clearly about the responsibility of a man for those crimes.
Okay. Well, I look at it from the eyes of as a former prosecutor, and it bothered me greatly. Thank you, Mr. Chairman.
Professor, good morning.
Good morning.
You know what a motion in limine is, don't you?
Yes, I do.
What is it?
It's a pretrial motion to exclude evidence.
Okay. Do you know what the Dober, some say Dober doctrine is?
Yes, it's also it's a motion regarding the inclusion of certain forms of expert testimony.
Good. Does a federal judge ever make law?
No, that's not the role of a federal judge. The role of a federal judge is to apply the law as it exists and is found in the statutes and precedents.
How about, you're familiar with the Fourth Amendment? Is there a statute that says what reasonable is under the Fourth Amendment? Don't judges all the time have to determine what reasonable means? Isn't that making law?
Well, that is a determination that's made under law in applying the facts of a specific case.
Yeah, but don't judges make law when they decide what reasonable means under the Fourth Amendment?
Well, they do in some sense make law. That's true. Justice Scalia once said, I'm not so naive to think judges don't make law, but they make law as though they are finding it.
So they do make law.
Well, in a sense, they decide cases and those become precedents.
All right, how about defining a restraint of trade?
Well,
I mean, is there a statute that tells us in every circumstance what restraint of trade is?
Well, the Sherman Antitrust Act is, one of the statutes that's referred to as a kind of common law statute where Congress has put forth a very general standard, and that's implemented by the courts.
Yeah, but don't federal judges all the time have to tell us what restraint of trade means? I mean, every case is not identical.
Yes, well, they have to make that determination.
So judges make law there too, don't they?
Well, in a sense, yes.
Okay. If you've got an ambiguous statute, do you think the president's opinion about the meaning of that statute is part of the legislative history?
The president who signed that statute, or the
right?
president?
He can sign it or veto it.
Mm-hmm. Well, I do think that it is in a sense part of the legislative history, but I think in general when interpreting a statute, it's best to focus on the text.
But do you think you should ignore what the president thought about it?
Well, I think, a court needs to consider the evidence that the parties put forward, and sometimes that includes legislative history or the opinion of the
Yeah,
president.
sorry to cut you off. I just don't have much time. Do you think that what the president thinks about a statute, the meaning of it, is part of the legislative history?
Yes,
Okay.
yes.
Let's suppose Congress passes a statute. It says, I'm going to read it slowly. I just made this up, okay? No person convicted of rape in any court can work in a battered women's shelter. No person convicted of rape in any court can work in a battered women's shelter. Now, the legislative history makes it very clear that in any court means a United States court. And someone is convicted of rape in a court in, let's say, Turkmenistan. What controls? Legislative history or the plain meaning of the statute?
Well, I think that the Supreme Court has made clear that where the statute is clear, that's the end of the inquiry. And in your example, the statute says any court.
So you would rule in any court?
Well, I think the part of the question would be also to look at the structure of the statute and the surrounding text to see whether any also included, for instance,
but
foreign
under
jurisdictions.
the plain meaning doctrine, and if you're an originalist, you don't look beyond the statute. It says in any court.
But there is sometimes a question of whether that has extraterritorial application, for
No, it
instance.
says
for
in any
Turkmenistan.
court. It means
Okay.
any court.
Well, any usually is pretty
Even though
inclusive.
Congress intended it just to meet, I mean, is that a case where you would ignore the legislative history and just go with the plain meaning of the statute, even though Congress obviously intended otherwise?
Well, I think if looking in the four corners of the statute and considering its structure and the other related provisions and looking at that, if it seemed clear, then there would be no need to have recourse to the legislative history because this text is what Congress enacted after all.
All right, okay. What is your, this is my last question, Mr. Chairman. What is your personal definition of life? When does life begin, in your personal opinion?
Senator, that is it's a difficult question, and it's one that's the subject of ongoing political disputes. And,
No, I'm not asking legally. I'm just asking you personally.
I guess I'm not exactly sure how to answer that question. As a judicial nominee, I hesitate to comment on an issue.
Why don't you just answer it for me honestly? Have you thought about it?
I mean, I have thought about it, yes, but it's the type of issue that is related to cases that could be pending before the court if I'm confirmed, and under the code of conduct, it wouldn't be appropriate for me to comment on that.
Let me suggest an answer to you. It doesn't matter. As a judge, you're supposed to follow the law.
Well, of course, Senator. My personal views, to the extent I have any, are put to one side.
And that's the point. I'm trying to rush through this, but others went over. We have nominees come before us all the time, and they're beat up for their past written opinions and their past law review articles and the past things they've said. I don't want a nominee that's never thought about the world. I'd prefer to have a nominee that has an intellect above a single-cell organism, that doesn't come in here as a blank slate. The issue is not have you thought about the world. The issue is, were you willing to put aside your personal beliefs and follow the law? So are you willing to put aside your personal beliefs and follow the law?
Absolutely.
Even if you disagree with the law?
Absolutely. That's the job of a judge.
Are you willing to rule in an abortion case in a way as dictated by the law, even if it contradicts your personal opinions about when life begins?
Yes, of course.
Thank you, Mr. Chairman.
Senator Blumenthal.
Thank you, Mr. Chairman. Welcome to our committee, and thank you for your service. This hearing is the first this session on judicial nominations, and it may be one of the most important that we do in this entire session. The court that you have been nominated to serve is certainly one of the most important. Those of us who live in the jurisdiction of the Second Circuit Court of Appeals might differ that it is the most important court, but there's no question that you will be making law and you will be a decisive and dispositive vote on this court. I'm not going to ask you about statements of 20 or 30 years ago that may make you cringe now. I'm going to ask you about more recent statements that make me cringe. And one of them is from November 18th, 2014, at a discussion co-hosted by the Federalist Society, where you lamented that the Rehnquist Court did not go far enough in reversing the Commerce Clause jurisprudence that had been in place since the court upheld New Deal policies in the 1940s. And you said, I'm quoting, they're able to invalidate things like the Gun-Free School Zones Act or parts of the Violence Against Women Act, which are really kind of grandstanding statutes. Do you believe the Gun-Free School Zones Act is a grandstanding statute?
Senator Blumenthal, no. That event was an.
Well, why did you say it if you don't believe it?
Well, I was responding to the person I was interviewing who had written a book about having more robust judicial enforcement of the Constitution, and that was in the context of asking him questions about things that he had written in his book.
This statement was made about 2 years after the massacre at the Sandy Hook School. I don't know whether you've ever talked to a parent who's lost a child in a school shooting, but I think if you had, you would never have referred to that statute as a grandstanding statute if you were aware of the very effective record of this law. In fact, the CDC found that in the years after the law was passed, school-associated student homicide rates decreased by more than half. That's just one piece of evidence. I hope that maybe you'll rethink that view. Did you believe then, and do you believe now, that the Violence Against Women Act is a grandstanding statute?
Senator, no. It's an important. Violence against women is a very important issue, and of course, it is a statute of this body. And if I were confirmed, I would have.
Well,
no problem
do you believe those two statutes? You said at the time that they are grandstanding statutes.
Well, Senator, I believe the context of those comments were responding to the author who had written a book.
You were responding to the author, and you said something that you don't believe.
Well, I don't.
What
recall
kind of
the
a
exact...
judge will you be if you say things that you don't believe?
Mr. Chairman, would it be too much to ask for the senators to let the witness answer the questions, because they're talking over each other and I can't understand?
Well, Senator, I was in that context interviewing someone who had written a book. Really, I was just the interviewee, and I was responding to things that he had written and said about the role of the Supreme Court.
Let me ask you about another article that you wrote in 2009 called "The President's Sphere of Action," stating your belief in a, quote, strong unitary executive. You said that, quote, the President may also decide not to follow Supreme Court precedent and in the rare instance may decide against enforcement of a particular judgment. Do you believe that the President of the United States has the power to defy a United States Supreme Court precedent or judgment?
Senator, that article was in general about the President's authorities in a range of different areas, and some other commentators have made that argument that in the very rare instance that is permissible. Some presidents have made that argument.
Do you think you've just answered my question?
Well, I'm answering your question as to what I was writing about in that article.
No, do you believe it?
Do I believe that? I believe that there are presidents in our history who have declined to enforce judgments of the Supreme Court.
You think that is constitutionally permissible?
I think it's a very difficult area. The Office of Legal Counsel has opined that a president can, in certain circumstances, decline to enforce an unconstitutional statute, and I think it's related to that concept.
My time has expired, Mr. Chairman. I'm hoping that we'll have another round. Thank you.
Are you familiar with presidential signing statements?
Yes, I am.
Are you familiar that every president, virtually on anything controversial about executive power, issues a signing statement giving their view of Congress's limited ability vis-a-vis the executive?
Yes, that is a common provision in executive signing statements.
Senator Hawley.
Thank you very much, Mr. Chairman. Thank you for being here. Let me just ask about, since we're talking about the Violence Against Women Act, the Gun-Free Schools Act, the United States Supreme Court invalidated portions of the Violence Against Women Act. Is that correct? Is that your understanding?
Yes.
And the United States Supreme Court invalidated portions of the Gun-Free Schools Act. Is that correct?
That's correct.
That would be the United States versus Morrison case and the Lopez cases, respectively. Is that correct?
Yes.
So you were not arguing for invalidating portions of these acts. You were commenting on, I assume, actions that the United States Supreme Court had already taken. Is that correct?
Yes.
Will you faithfully follow precedent of the United States Supreme Court as an inferior court judge?
Yes, Senator.
Will you do it regardless of your beliefs in whether it's about the Violence Against Women Act or Gun-Free Schools Act or any other act that the United States Supreme Court has a binding precedent regarding?
Yes, Senator. I would put any personal views I had to one side.
That would be a refreshing change from many judges on our inferior courts currently, I have to say. Let me ask you about interpreting statutes, picking up what Senator Kennedy was talking about. He asked you about some particular tools. Can you just walk me through how you approach a statute? And when you think about the different tools that judges use to interpret a statute, text, structure, history, legislative history, dictionaries, philosophy, sometimes foreign law. Can you give us a sense of what you would prioritize? A precedent, of course. What would you prioritize in terms of those tools, and how would you go about the business of interpreting an ambiguous statute, which, of course, you'll see every day?
Yes, thank you, Senator. So, of course, as an inferior court judge, I would look to the precedent of the Supreme Court to see how they've interpreted a particular statute. But, you know, really the beginning of the inquiry is the text of the statute, and that's where the Supreme Court said we should start. And, in trying to understand the text of the statute, would look at the specific words of the statute, other related provisions within that statute, the structure of the statute, how the provisions fit together, and oftentimes, that will be sufficient to yield an answer as to the meaning of the statute. But of course, as a judge, I would consider other arguments raised by the parties before me, and that may include other tools such as legislative history or other materials.
Tell me about legislative history. I mean, how does that fit into your understanding? I mean, you start with text, structure, history. How do you think about legislative history? And I ask because this is a live debate at the United States Supreme Court, and the Supreme Court's guidance on this issue is somewhat conflicted. You have justices who say that they'll never consult legislative history. Of course, the court has made a practice of consulting legislative history, but in different ways. So there's quite a bit of ambiguity there. How do you think about this important issue?
Sure. Well, I think that there's become somewhat more unanimity on this issue. I mean, Justice Kagan said recently, right, we're all textualists now, and I think that's in part because there are constitutional reasons for that. The text of the statute is what went through the House and the Senate and was signed by the President, and so that is the law under the Constitution. The legislative history is of course, the understanding of some members of Congress, and there have been many reasons given by the Supreme Court for why its use should be limited.
Let me ask you about your area of expertise, your particular area of expertise, administrative law, which of course is an area that you'll see quite a lot of on this circuit. Should you be concerned, this is an area of law that also is in a state of change, and the United States Supreme Court has recently indicated or been sending signals that it may be willing to revisit some of the foundational precedents. I think Senator Cornyn may have asked you about the Chevron case. Thinking just for a second about the King versus Burwell case, a controversial case for a lot of reasons, but that was a case where one would have thought the court might have applied deference or invoked deference. It did not, and instead the court majority said that it is courts, not agencies, who have the primary role in interpreting statutes. The court expanded what appeared to be the significant questions exception to the Chevron doctrine. My question is, how do you think about, given the case law, the state of the case law, how do you think about Chevron deference? What is your sense of where we are when it comes to deference to administrative agencies?
Well, Senator, Chevron has not been overruled by the Supreme Court. As you said, there is a debate amongst some justices and including in Congress about the appropriate scope of Chevron, but it hasn't been overruled. So if I were to be confirmed, I would continue to follow that precedent.
What are your thoughts about political accountability of agencies and what role that courts should give to that value when reviewing agency adjudication?
Senator, I think political accountability is very important in agency decision-making. It's part of the legitimacy of what happens with regulatory policy, which is that regulatory policy is set under statutes enacted by Congress, but implemented consistently with the democratically elected president's priorities.
Thank you, Mr. Chairman.
Thank you very much, Ms. Rao, for being here. One cannot escape the national debate over the last 4 or 5 days involving the governor of Virginia and actions, conduct, or statements that he made many years ago, and whether he should be held accountable today for those statements or that action, and whether that affects his ability to serve in public life. Are you familiar with that debate?
Senator, I've seen some of the articles.
It is interesting as we consider nominees, yourself included, that we look into their backgrounds as to what they've said and done in the past as some indication of their values and their judgment. And you have described your early, and I might add, controversial writings as cringeworthy, inelegant, and at one point idealistic, which was kind of hard to reconcile in my mind. What do you think should be the level of accountability of a person seeking a position such as you are for things that they have said and done even 20 years ago?
Senator Durbin, respectfully, that's an important question for this committee, but as a nominee sitting before you, I think it would be presumptuous to comment on how this committee does its advice and consent function.
I'm asking you the human side of this, as Senator Kennedy did. I'm asking you what you think in terms of, well, let's go back. I mean, there were times at Yale when you were just downright controversial. Your statements on date rape have been quoted and requoted over and over again. You've said in response to the chairman here that you were just trying to warn women to use common sense to avoid sexual exploitation. Do you consider that idealism on your part or cringeworthy?
You know, Senator, some of those comments or the way I expressed myself, I certainly regret, but I was also very clear about the responsibility that men have when they commit those horrible crimes.
I could quote from the article, I won't, but there are things that you said which contradict the statement you just made. I want to talk about myths for a moment. You also said at Yale that a group called the Bisexual, Gay, and Lesbian Co-op was, quote, spreading myths about AIDS. What were you referring to in that statement?
You know, Senator, my attention was drawn to that. I honestly do not recall.
Well, then let me ask you about another myth statement. In November of 1993 in the Yale Free Press, you wrote an article entitled Submission, Silence, Mediocrity, Myths of Sexual and Racial Oppression Propagate Themselves, Create Hysteria, and finally lead to the formation of some whining new group. One can only hope to scream, perspective, just a little perspective, darling. What are the myths of sexual and racial oppression that you were referring to in that article?
You know, Senator, I don't recall precisely, but it's, you know, look, I've always been someone who has taken problems of sexism and racism very seriously, and you know, partly what I'm responding to there is a very narrow set of issues on the Yale campus and a specific type of activism and multiculturalism that existed at Yale at that time. And, you know, I guess I always thought it would be best to have more tolerance and understanding rather than dividing people up into groups.
Tolerance of sexual and racial oppression, is that what you're asking for?
No, tolerance of racial differences, understanding between different racial and ethnic groups.
I don't think that's consistent with labeling sexual and racial oppression as a myth. Do you have any doubt in your mind that there has been throughout history and even in our country oppression of people because of their gender and race?
No, I do not.
Well, your early writings raise questions about your values and how many of those you bring to the table today and want to take into the future into a courtroom. And I think those are legitimate inquiries on our part. And I just cannot reconcile something which is cringeworthy and idealistic. How do you reconcile those things?
Well, Senator, I think I had a kind of idealism about racial relations. I went to a school that was very diverse. I had friends from all different backgrounds, and as a growing up as an ethnic minority, I guess, as it were, I was inspired by Martin Luther King's vision, right, that we should be judged by the content of our character and not the color of our skin. And maybe that does seem idealistic and naive today, but that was inspirational to me when I was starting college.
Ms. Rao, I would really struggle to reconcile what you said about racial oppression as a myth with the legacy of Dr. Martin Luther King. I can't understand that brand of idealism. Thank you, Mr. Chairman.
Thank you. Senator Lee.
Thank you, Mr. Chairman. I want to start by asking a few questions about a topic that I know is everyone's favorite, which is the intersection of administrative law and constitutional law. In my small town of Alpine, Utah, we speak of little else. Now, there are some people who think of this as some sort of distant, esoteric topic, but it's not. You and I both know that this is part of the functioning of our republic. In Federalist number 47, James Madison wrote that the accumulation of all powers, meaning legislative, executive, and judicial, is itself something that doesn't just lead to tyranny, it is the very definition of tyranny itself. And Tocqueville predicted that if tyranny ever came to the United States, it would take the form of an immense and tutelary power, one that would regulate every minute detail of people's lives. And so these topics are not merely esoteric. They're not merely something that could be described as philosophical. They have a real impact on the rights of individuals, on the freedom of people within a free society. And they're essential toward safeguarding our own liberties, because anyone, any country in its constitutional system of government, if it has a constitution, can claim to have a Bill of Rights. But whether or not that Bill of Rights means anything depends for its security, for its enforceability on the protection of the people by means of prohibiting anything that would lead to the excessive accumulation of power in the hands of the few. And this gets us to what you have focused on throughout your academic and professional career in administrative law. As you know, there's been a lot of debate in recent years about whether Chevron and our deference are lawful. Unless or until the Supreme Court changes the law, courts are required to defer to agency interpretations of ambiguous statutes and regulations. But one problem with these rules is that ambiguity may mean different things to different people. So I guess my first question for you is, do you think you're more or less likely than others to see a particular provision in a statute or regulation as ambiguous?
Thank you, Senator Lee. It's hard to say in comparison with others but I do think it's important when looking at one of these cases to consider the statute for all that it's worth, right? And sometimes a provision that may seem ambiguous at first blush is not ambiguous when you really take into account the statute as a whole, its structure, how the provisions relate to one another. And I think there's usually a lot of meaning that can be found from the text of the statute.
What happens when Congress excessively delegates its power? Is that a problem?
Well, Senator, the Supreme Court has recognized in all of its cases relating to the non-delegation principle that non-delegation is a cornerstone of separation of powers. The Constitution does give the legislative power to Congress, in part because they are democratically accountable to the people. So that has always been recognized as an essential principle in our system.
A lot of commentators defend the present doctrine on the grounds that it's impossible to formulate a judicially manageable principle by which to apply the non-delegation doctrine. On the other hand, some would argue that it's a problem anytime a non-delegable duty is delegated. What's the best way to resolve that dispute?
Well, it's a difficult question. I mean, the Supreme Court has on the one hand, recognized the importance of non-delegation, but used a standard, the intelligible principle standard, to judge whether Congress has in fact delegated its authorities. And of course, I would be bound to follow that precedent if I were to be confirmed. And you know, it's something though that some justices have raised questions about, and as you know, it's something I've written about in my scholarly writings.
Right. When we speak of the judicial manageability of a standard, what are we referring to? When we've got a standard that's whether or not it's judicially manageable, tell us what that means.
I think that standard means, you know, is there some legal standard that the court can apply in that particular case? Is there some provision of the Constitution that the court can apply?
Okay. I don't have anything to add on the substance of your college writings. You've done a good job of explaining the content and the context and what you were trying to accomplish. But I do want to take a step back for a minute. There's a new reality that's set in, which we've had more than a few nominees who have been criticized for their college writings. We've even scrutinized at least one nominee's high school writings. There are some things you can write in college that could disqualify a person from later subsequent service in political life, either in the judiciary or otherwise. For judges, I think the standard should involve whether the writing in questions shows that the person cannot be impartial. And it is quite obviously not what we're dealing with here, not anything close to that. For the most part, I think someone should be allowed to say, look, when I was young and I saw things differently through the eyes of a young person, I said X. And I'm sure you've reread those articles and winced at parts, as you've indicated. There are some passages, and I'm sure some articles that you wish you hadn't written, or if you were to write today, you would write differently. But I think the same could be said for everyone in this room. The same could be said for everyone I know who went to college and has later gone on to do something else. People grow, they learn, and we should allow that those changes to be taken into account. There's certainly nothing disqualifying here. And I'm certain that there aren't many people in America who want to be judged by what they said in college. But here's the deeper issue. Judicial nominations, if I can get one more sentence. Judicial nominations have become a blood sport, and we've convinced ourselves that because judges are important, it's all fair game. That's not right. That shouldn't be the case here. Thank you.
Senator Klobuchar.
Thank you very much, Mr. Chairman. Administrator Rao, I wanted to clarify one thing. I believe you said to Senator Feinstein that you will not commit to recuse yourself from cases involving regulations you worked on in the administration. Is that right?
No, that's incorrect.
Okay.
I think recusal is a very important issue, and as I said, I would take it in a case-by-case manner. I would carefully consult the statutory standards. I would follow the precedents of my colleagues. There have been a number of people who have gone from executive branch service to the D.C. Circuit, and I would certainly discuss with them.
So you're not going to commit to recusing. You're just going to look at them case by case.
Well, I haven't been confirmed yet. I've not been a judge, and so I would need to look at those recusal issues carefully, and I would take that obligation very seriously.
Okay. In August of 2018, the administration announced a replacement for the Clean Power Plan, and that would have reduced carbon dioxide emissions. Many of us were involved in that. According to the EPA's own data, this could lead to 1,400 additional premature deaths a year. Is that a case you would recuse yourself from if we were to enact a similar bill or a rule like that would come up to you?
Well, Senator, that rule has been reviewed at OIRA, and so I would apply the recusal statute standards to that. There's not been a final rule, however, that has been reviewed by my office. Okay,
and do you believe the costs of that rule outweigh those benefits?
Well, there is, partly what's been done is we have continued to use some of the analysis from the previous administration and show the range of uncertainty about what some of the impacts of the rule would be. And that rule is currently in the proposed stage. There were many comments, and the two, EPA and the Department of Transportation are working to finalize that. Or, I mean, I guess.
So you don't have a
sorry.
view on the cost benefits on that?
Well, that's something that we have reviewed and worked with the agencies on, and we haven't yet seen the final rule.
The Trump administration has a 5% success rate. This is according to the nonpartisan Brookings Institution report released last October. The administration has a 5% success rate when defending its agency actions in court. Previous administrations have had an average 69% success rate when defending their actions, and that includes Republican administrations as well. In your current position, you're responsible for reviewing agency actions to make sure they're supported by facts and evidence. So this suggests to me that the administration is taking agency actions that are far outside of the mainstream, especially when we know judges are deferential to agency actions. How can you explain this sharp decline?
Thank you, Senator. You know, I have seen some of those studies. You know, there are, of course, different ways of counting the litigation record in the courts, but I think it's a part of every administration that individuals and businesses challenge regulatory action, and our courts respond to that. Some of those cases are still going up on appeal. Some of those are about rules that were decided before I was confirmed to my current position.
Okay. You've been extremely critical of the Consumer Financial Protection Bureau, saying that you, quote, hope a lot of what the Bureau did will be rolled back. You also wrote that the structure of the Bureau is unconstitutional because the president can't fire the director. As we know, it's given back the Bureau $11.7 billion in relief to 27 million consumers in the U.S. If you're confirmed, will by the D.C. Circuit, in the D.C. Circuit, you're going to hear challenges to the Bureau's rules. How can we expect you to give fair consideration given these past statements and suggestions and recommendations you've made?
Well, Senator Klobuchar, those were writings that I did as an academic commentator, when I had the freedom to speculate on abstract questions of law. Of course, if I were confirmed to the D.C. Circuit, I would have a very different role. I would put aside those academic views. I would follow the precedents of the Supreme Court.
Would you uphold Chevron?
Chevron is a precedent of the Supreme Court, and yes, I would follow it.
In a 2014 Law Review article, you wrote that the Constitution requires that the president be able to, and this isn't a high school writing, this is Law Review, that the Constitution requires that the president be able to fire at will the heads of independent agencies, such as the FTC, the SEC, and even the Federal Reserve. Can you cite any majority opinions of the Supreme Court that support your view that the Constitution would require this?
Well, Senator, there's the Myers case, the early case, and but currently, I mean, my article was about the structure and text of the Constitution and looking at that in a sense. But I recognize in that article that Humphrey's executor is still good law, and if I were to be confirmed, I would follow that precedent with respect to the constitutionality of independent agencies.
Thank you.
Senator Tillis.
Thank you, Mr. Chair. Ms. Rao, thank you for being here. I wanted to go back and maybe give you an opportunity. I think that Senator Cornyn spoke up when you were having an exchange with Senator Blumenthal. Could you better describe the context of the role that you were playing in the interview where the Violence Against Women in School Safety Act came up and the word grandstanding was brought up? Can you describe that better for maybe reporters and other people who may take some sound bites out of here versus the full context of that experience?
Sure. That was. I haven't reviewed that interview in some time, but it was about a specific book. I think the book was called Overruled, and the author was arguing for, I guess, more judicial involvement in reviewing statutes carefully, and so we were having a discussion about just how active the court has been with respect to hearing challenges on the Commerce Clause. And of course, those are the statutes that are referenced. The Guns Free School Zone Act, the Violence Against Women Act are important statutes, and it was not my intention to disparage them.
Yeah, thank you. I think Senator Hawley did a good job of describing some of the other actions there, but I thought it was very important because I can just see as I walk to the Capitol later today, how they're only going to remember a context, or I think it was presented out of context. I want to give you an opportunity to respond to that. Can you tell me what your ABA rating is?
Yes, I was rated well qualified.
Well qualified. And if I recall, I think it was someone who came before this committee, other members who have expressed a concern about your experience, Kagan, now Justice Kagan, probably had kind of a similar profile and experience to your own. Is that right, in your recollection?
That is also my recollection.
And I understand that she enjoyed a lot of support, actually support from both sides of the aisle. The only other question that I have really relates back to some of your writings earlier. Somebody has said that we're, I guess, cringeworthy. They've used the various different descriptions. But tell me what motivated you to, what sort of life experiences or other factors back at that time when you were in school motivated you to take on some of these issues? And if you were to write them today, are you saying that you're stepping away from some of the concepts, or you just do a little bit more eloquent job of describing conceptually what you were beginning to form as a young person in school?
Well, thank you, Senator Tillis. I think that maybe a little of both.
So which ones would you just say, that was dumb, I should have never done it? We've had people come before the committee and do that. I'd like to know that one maybe first.
Well, I think that there's certainly some sentences and phrases I would never use today, and you know, I've just, you know, because they don't reflect my views, they don't reflect the way that I express myself. You know, I think it's also important to consider the context of what was writing at Yale in the early 90s, right? We were a bunch of kids on a liberal arts campus writing for each other, right? And there were 35 undergraduate publications, and I think we all fashioned ourselves scribblers on the current events on campus. And, you know, I think it was just a specific time, and you know, and frankly, a lot of the quotations that have been mentioned here aren't even a full representation of all the many columns I wrote while I was at Yale on a whole range of different topics. And you know, the committee also has before it my records since I left college, which includes all my scholarly writings, my speeches, my congressional testimony, my public service, my service at OIRA. So hopefully that can all be taken in context.
I hope so, because in a couple of instances, you know, you kind of get a read for how the narrative's going to go around here by the questions various people in the press ask you. Some are legitimately asking questions because they're curious. Others are trying to build a narrative, and I would really encourage them to go back and understand the context in some cases, and in other cases where you've simply changed an opinion because you've witnessed more sunrises and sunsets, and you're a wiser person today than you were back when you were in college. So again, you know, for those who say that your experience is a concern, they should go back and look at people that they have enthusiastically supported, who had very similar profiles, one who's actually a Supreme Court justice now. And we should keep in mind that the ABA has rated you well qualified, and that's why I'll be supporting your nomination.
Thank you, Senator.
Senator Whitehouse.
Thank you, Chairman. Ms. Rao, I worry less about what you wrote at Yale years ago than whose interests you serve right now at OIRA and how that will move over with you into the D.C. Circuit Court if you are confirmed. We hear a lot in this committee and in the press about how the president is trying to push through lots of conservative judges. I actually don't see much conservatism in those judges. What I see is judges who are predictably likely to rule for specific big special interests. And you see the hands of those special interests in the process of selection. We'd like to know more about it, but the Federalist Society doesn't disclose its donors very clearly. We do know from the White House that the White House said that it insourced, that's their word, insourced the Federalist Society to make their selection of the last Supreme Court nominee. We then see a confirmation process that is just rotten with dark money. One donor, nearly $18 million. We don't know who that donor is. And then we see these same groups turning up in front of the courts, Circuit Court, Supreme Court, as amici. It's not always easy to figure out who's behind the amici because the rules are very vague about disclosure, even in the court. It's probably the worst policed form of influence seeking in our government right now. But what I see over and over again is an instinct to protect the role of dark money, because dark money is the vehicle for all these other powers. I see an instinct to protect big polluters at all costs, as if there's no public on the other side of the regulatory balance. The firearms lobby, big instinct to protect them, and a very strong lean in favor of corporate political powers and against the accountability of corporations either to an honest, knowledgeable regulator or to a court or a jury. Now, the courts and juries were kind of set up to deal with this problem because the Founding Fathers knew about special interest influence in legislatures and in the executive branch. But what I see from the courts is a desire to move as many questions as possible to those areas where the special interests have the most power. And I think that's a matter of real concern. What makes me say that this is not a conservative judicial doctrine is that when you look at conservative judicial doctrines, they include things like respect for the will of elected branches, like judicial modesty, narrowing the decision to what's least required to decide, stare decisis, respect for precedent, and that famous Scalia-ism, originalism. In various cases, every single one of these so-called conservative judicial doctrines has been completely run over in the path to delivering a win for the big donor interest. So it's hard for me to align conservative judicial doctrine with what's going on here, which is why I say these aren't conservative judges any longer. This is basically an effort to capture the court for big special interests with judges who will rule predictably for those big interests. Time will tell in your case. There's nothing I can ask you to answer here now that will divulge that you're going to go in and put your finger on the side of the big polluters. You're going to put your thumb on the scales for the firearms industry. You're going to help corporations avoid accountability or any of that. But time will tell. And time is already telling at the Supreme Court. And that's what I want to make a record of here today. The Supreme Court is now up to, I want to say, 73 partisan decisions, 5-4, with Republicans and Democrats allied on different kinds in the Chief Justice Roberts' tenure. So call them the Roberts Five, the activist Republicans. 73 decisions in which they've had a particularly important issue for Republican interests in front of them. And in all of those partisan 5-4 decisions, the big donor interest won. 73-0. This from a guy who said he was calling balls and strikes. Give me a break. Helping Republicans win at the polls has been a constant theme of the court, whether it's hurting unions or helping dark money or allowing voter suppression or protecting and enshrining gerrymandering, helping corporations avoid accountability, totally with no mention of the Seventh Amendment, with regard to protection from their employers who might be discriminated against, consumers who might be injured, or other parties injured by their actions. And then, of course, there are the big donor interest wins for polluters and for the gun lobby that just get thrown their way almost like it's a Christmas present. So what I see is a court that is predictably likely, indeed infallibly likely in these 5-4 decisions to vote for big Republican donor interests. And I think it's time we clean that mess up, and I think that that is, in the long run, going to do a real disservice to our courts to have a record like that of having so almost slavishly followed those interests in those circumstances. So I hope you'll do a lot better if you get on the court and not just fall into that rut.
Okay.
Senator.
Senator Hawley. No, I'm sorry, Ernst. Ernst, I'm sorry.
Thank you very much, Mr. Chair. And Mrs. Rao, you've been nominated to serve on the D.C. Circuit. And although the D.C. Circuit can be described as primarily handling federal administrative law, I believe that judges who serve on this very powerful court need to share the same values and morals as any other judge. And that includes a number of sensitive topics and concerns that I and the vast majority of the country hold dear. And so I'm not going to mince words. A couple folks here have touched on it. I've had a chance to review a number of your writings while you were in college, and they do give me pause. And not just from my own personal experiences, but regarding a message that we are sending young women everywhere. And I've said time and time again that we need to change the culture around sexual violence, from our college campuses to the U.S. Olympic Committee to our military and beyond. And a large part of this is ensuring that young women feel comfortable sharing the stories and experiences that they've endured, and that they are given a chance to be heard, and that they know that we hear them and that someone out there actually cares about them. I'm thankful for the opportunity to serve on this committee. I'd like to discuss some of these issues with you today. So right out the gate, do you believe that rape is wrong?
Absolutely. It's a horrific crime.
And who is at fault in a rape?
The rapist, the man who commits the rape is, of course, at fault.
Man or woman?
Man or woman, but
right.
Often the man.
You wrote on these matters in college, which were about 25 years ago, and just describe how your thinking has actually evolved on these matters, as a number of my colleagues have asked.
Thank you, Senator. I've had a lot of experience since that time writing in college, and I don't think I would express myself in the same way. These are horrible crimes, and I wouldn't write anything that might be implied to blame a victim or make it less likely for a victim to come forward. I think it's very important that women on campus and elsewhere feel free to bring forward claims of sexual assault or rape.
Mm-hmm. Thank you. I appreciate that. And in your writings, you did talk a lot about date rape in the context of college campuses. We know it does happen elsewhere. Discussing the concepts of blame and responsibility. What has informed your decision as you have moved through the years, and how have you come to understand that maybe no one is, or the victim is not to blame, or the survivor's not to blame? Maybe explain that to us, how you have informed your decision through the years.
Sure. A victim of a horrible crime is not to blame, and a person who commits those crimes should be held responsible. I tried to make the common sense observation that women can take certain steps to try to avoid becoming a victim, because that ultimately does seem to be the goal in making it less likely. But should someone be a victim, then they should not be blamed, and there's the responsibility is with the person who commits the crime.
Okay. I'd also like to ask you, also in the feminist dilemma, there was a comment that you made. You state that Camille Paglia's view on date rape has often been criticized for its insensitivity because she seems to, quote, blame the victim. Paglia, however, accurately describes the dangerous feminist idealism which teaches women that they are equal. Is that a dangerous feminist ideal? Is that women are created equal?
Senator, I very much regret that statement, and I've always believed strongly in the equality of women and men, and for equal rights and opportunities for women. I'm honestly not sure why I wrote that in college.
Okay, I'm glad to hear you admit that today, because I would hate to think that women would not be treated equal under the law.
Of course, and if I were to be confirmed, I would treat all people who come before me equally and administer justice without respect to persons.
Okay, I appreciate your explaining some of the views that you had from college. I hope that we can have further conversations about this.
Yes, thank you.
I yield back my time.
Thank you. A statement from a prior nominee. I would hope that a wise Latino with the richness of her experiences would more often than not reach a better conclusion than a white male would. You didn't say that. Sotomayor said that, Justice Sotomayor. And the argument from my side was that she's biased, and when you look at her life, I didn't believe that. When I look at your life, I think you're a very fair, squared-away person. Senator Hirano.
Thank you, Mr. Chairman. I ask these two questions of every nominee who comes before any of my committees. They are, since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
As a law professor, you continue to be critical of affirmative action programs. For example, in a 2009 Law Review article, you argued that such programs, I'm quoting, confirms and reinforces traditional and historical associations between race and disadvantage and imposes what you term dignitary harm. Not sure what that means. What does that mean?
Well, Senator Hono, that is an article about different conceptions of dignity in constitutional law. The term dignity is used by the U.S. Supreme Court and other constitutional courts in other countries, and that is it was an attempt as an academic to explain the different senses in which dignity was used in those cases. So that was the context of that writing.
Is that something that you would apply to any cases that come before you, whether or not a regulation or any issue that came before you imposes dignitary harm?
No, Senator, of course not. These are very academic and abstract discussions of a concept of dignity in specific cases. Those are all things I would put to one side. If I were fortunate enough to be confirmed, I would follow the precedents and the law in cases that come before me.
Here's an actual situation. I think you responded to something that happened in France where they made dwarf tossing illegal. And I think that you said something like, it's up to them whether this was an individual decision, but why wouldn't, it would seem as though your writing about dignitary harm would apply to something like dwarf tossing, wouldn't it?
Yeah, Senator, thank you for the opportunity to clarify that. Again, it was I wrote about a particular case in France that used different conceptions of dignity. There was a town in France that banned dwarf throwing. There was an individual, Mr. Wackenheim, who made his living doing that, and he said that this ban affected his dignitary interests. But in my article, I don't take a position one way or another on these issues. I'm just pointing out.
I think your article has been interpreted as that you were okay with dwarf tossing. This is one of the reasons that an organization that supports their issues is very much against your nomination. After Elena Kagan was nominated to the Supreme Court, you criticized the confirmation process, and you wrote that nominees are, and quote, coached to choose from certain stock answers, quote, and continue to quote you. Nominees are confirmed based on platitudes, and public discourse suffers as a result. You argued that nominees should not be confirmed, quote you, based on incantations of the right formulas without an examination of their actual beliefs. And I must say, sitting here through all of the dozens and dozens of nominees that we have had that we've had hearings on, that what we do get are platitudes, and I believe that public discourse suffers because it's very difficult for us to ascertain what your actual beliefs are. And since you believe that we should get to the actual beliefs, it must be because you believe that judges do make decisions based on their actual beliefs. Is that not so? Isn't that why you criticize the confirmation process?
Well, Senator Hirono, in that article, I suggest that a nominee's views on judicial philosophy and how they would decide cases are fair game for discussion, and I've sought before this committee to give straightforward answers to those questions.
So are you saying that because you have sat here saying, as does every other nominee, that you will follow precedent, and we all know that even as Justice Rehnquist said, judges do not come here as blank slates, that you have a wealth of experiences and you bring those experiences to the fore, including various kinds of ideological perspectives that you may have. There is absolutely no question in my mind that a judge's actual beliefs is what's impelling a lot of the decisions, and that not just following precedent, because a lot of times precedent is not on all fours applicable to any case before you. So are you saying that you sit here and tell us that you have been disclosing your actual beliefs because you didn't respond to the question that he's not a justice yet, that my colleague asked you about when life begins?
Well, Senator, I come here to this committee with no agenda and no ideology, and I would strive, if I were confirmed, to follow the law in every case.
That is what they all say. Thank you.
Is it ever appropriate, and what would be your view of using foreign law as a decider in a case? And when is it proper, is it even proper to make a referral to it?
Thank you, Senator Grassley.
The law of some other country.
So there may be some instances where the law of some other country is at issue under a contract or in some other way, and then that would be the applicable law. But foreign law is not generally used to interpret our Constitution or U.S., our federal statutes.
You said generally. When is it appropriate or not appropriate?
Well, I think it's generally not appropriate.
Okay. Would it be wrong to say it's never appropriate?
Well, there are some constitutional provisions that rely on the law of nations and things like that. So there are some contexts in which foreign law and international law would be appropriate to consider.
Now, I know you're bound by Supreme Court precedent. When, if ever, would it be appropriate for in your circuit to overturn precedent?
It's not appropriate as a court of appeals. We are absolutely bound by the precedents of the Supreme Court.
Yeah, I know that. You didn't hear the clarification.
Sorry.
I know you're bound by Supreme Court. When would it be appropriate for a precedent of your circuit to be overturned?
Oh, sorry, Senator Grassley. Well, there are considerations. Normally, you want to follow precedent, but there are certain features when a precedent may be overruled. You look at the longevity of the precedent, the reliance interests. There are certain standards for when a precedent may be overruled.
Define for me what you think about the terms activist judge or definition of judicial restraint.
Sure. So I think an activist judge is often seen as a judge who goes beyond the law to reach a particular result, and I think it's important for judges to follow the law wherever it leads them and whatever result it leads them to, and I would strive to do that if I were confirmed.
What assurances or evidence can you give us that if confirmed, your decisions will be grounded in that precedent and the text of the law rather than any political ideology you might bring to the bench?
Thank you. I think, I having had experience in all three branches of the government, I have a good appreciation for the different role that each of the three branches play. And the independence and impartiality of our judiciary is essential to our system. And if I were to be confirmed, I would work to uphold that in every case.
My next question isn't going to determine whether I vote for you or not, but I want you to know that I'm very much an advocate for cameras in the courtroom, including your courtroom if you're on that circuit, including the Supreme Court, although that gets a little more controversial. But what are your views of cameras in the courtroom?
Senator, I don't have a view on that subject. I know it's one that's been discussed and debated, even since I was a counsel on this committee many years ago.
You're going to go to work on the circuit with the least case, I think it's the least caseload of any circuits. What do you think about the caseload of your circuit?
Well, I do understand that there are fewer cases in the D.C. Circuit, but my understanding is that many of the appeals that come are highly complex and so often much more detailed and difficult. So
you're lucky that I probably would not oppose you just for the reason that there's too many judges on that court already. There's going to be a time when we ought to get this down to at least 3 less than it is right now, to spend the taxpayers' money wisely and to make sure that the caseload from one circuit to another is more fair. At this point, I wouldn't. One time we reduced the circuit by taking somebody from the D.C. circuit and put them on the 9th Circuit. I'm not sure that was a wise decision, but at least it did reduce the judgeships in your circuit by 1. So I hope there's another vacancy that we can just not fill.
Okay. Senator Harris.
Thank you. Ms. Rao, in 2016, the Obama administration enacted the Volks Rule, which allowed OSHA to issue citations to employers for failing to keep a record of work-related injuries over a 5-year period. In April of 2018, the current president signed a law repealing the Volks Rule, and in a speech that you gave before the United States Department of Chamber of Commerce, you applauded the rule's repeal. According to OSHA, are you aware that more than 5,000 workers were killed on the job in 2016, and on average that is more than 99 deaths a week and more than 14 deaths a day?
I'm not familiar with those specific statistics.
Do you believe that when government is required to keep data and when employers are required to keep data, it allows us to be better in terms of public policy and ensuring that we avoid issues like workplace injuries and deaths in this case?
Yes, it certainly can be.
So why did you applaud the repeal of the rule?
Well, Senator, just to be clear about, my role at OIRA, we review rules that come up from agencies. Those policies are set.
But let's
by the
talk specifically about this one. Why did you applaud the repeal of the Volks Rule?
Senator, I don't actually recall discussing that in that speech.
This was just in 2018 that happened. You don't recall what happened last year?
I don't know.
Okay. You said when having a conversation with Senator Ernst, you said, quote, women should take certain steps to avoid becoming a victim. What steps do you have in mind that women should take to avoid becoming a victim of sexual assault?
Senator, it's just sort of a common sense idea about, for instance, excessive drinking. That was advice that was given to me by my mother.
So that's one step you believe women should take to avoid becoming a victim of sexual assault?
It is just a way to make it less likely. It's not to blame the victim. Rape and sexual assault are horrible crimes, but we're talking about what can you do to keep yourself safe.
Are there other steps that you believe women should take to avoid becoming a victim of sexual assault?
That is one of the issues that I discussed. I'm not sure if there are others.
So do you believe if a woman does not take those steps that she is at fault or partially at fault for what happens to her?
No.
So what is the significance of taking those steps?
Well, I think it's just the significance of trying to avoid becoming a victim of any crime, right? We take different steps to try to protect ourselves from horrible crimes such as rape, and and I think what we want is for women to not be victims.
So your previous writings on date rape and sexual assault have been mentioned many times in this hearing. They certainly express strong opinions about the subject, and for that reason raise concerns about your current perspective on these issues. You have, for example, in '93 said that, quote, date rape exemplifies the attempts of the nurture feminist to develop an artificial alternative world in which women are free from sexual danger, and no always means no. In your current view, when does no not mean no?
Senator, no means no, and I regret writing that when I was in college.
And you said that a good way for a potential date rape to be avoided is for a woman to stay reasonably sober. You went on to say if a woman drinks to the point where she can no longer choose, well, getting to that point was part of her choice. Do you stand by those comments?
Senator, I was only trying to make the common sense observation about the relationship between drinking and becoming a victim.
So I'm concerned about your current views. Do you stand by those comments?
I do not, and I would not express myself that way today.
Okay. And last week, I joined 35 of my colleagues in the Senate urging the Department of Education to rescind the proposed rule that would narrow the definition of sexual harassment and require colleges to provide live in-person hearings where an accused representative can cross-examine a survivor. We oppose the rule because it fails to account for the experience of survivors and it hampers schools' ability to respond to complaints. Under your leadership, has the Office of Information and Regulatory Affairs evaluated this proposed rule?
We did evaluate that rule. It's currently a proposed rule, and the comment period just closed last week.
What's your opinion on the rule?
Senator, my opinion on that rule is not what's relevant in my current position.
Well, I would argue it is relevant because if you are actually confirmed on the D.C. Circuit, you of course will be responsible for reviewing regulatory appeals. So, under your leadership, if the office has reviewed this rule, what is your opinion about its efficacy?
Well, Senator, this is a policy of the Department of Education, as you stated, and they drafted the rule. You know, my understanding is there were thousands of comments from the public. We take that public process of notice and comment rulemaking very seriously, and it will now be up to the Department of Education to consider those comments in terms of finalizing the rule, in which we haven't seen that final rule yet, but we will take, one of the things we do at OIRA is make sure that the agency has responded to the comments.
And my last question, Mr. Chairman, if you, once your office under your leadership has commented on the proposed rule, will you commit to recusing yourself to any challenges on this rule if it is litigated before the D.C. Circuit and you are confirmed?
Well, Senator, again, you know, I will take recusal very seriously. I noted in my questionnaire that some of the issues arising at OIRA will require recusal, but I can't prejudge what those would be until I have a case before me.
Thank you.
Senator Blackburn.
Thank you, Mr. Chairman. Welcome. We appreciate that you're here. I have to tell you, I think what an amazing career you've had. University of Chicago Law, and then clerking at the Supreme Court, working in the White House, running a major regulatory agency, quite a resume, and I find it so interesting that much of the day's focus has been on writings that you did during your college years. I do want to come to one story that I think is so interesting, your story, your parents' story of immigrating here from India, which really does represent so much of what we cherish as the American dream. And there's an article that you wrote about bringing a friend to your family's Thanksgiving dinner. So I want you to speak, you know, cap that story quickly, and then speak a little bit about how that and your family's experience really helped to shape your identity.
Mm-hmm. Thank you, Senator Blackburn. So the column that you referenced, I took my friend Dan, who is an Irish Catholic, to Thanksgiving with my friends and family, and so he got to see sort of the whole range of what happens at Thanksgiving with the Rao family, which included many different meals and lots of people, lots of questions about whether he was my special friend, which he was not. Otherwise, obviously, I wouldn't have brought him to this event. But really, it was about celebrating all the closeness and love that my family and friends had. And although my parents were immigrants from India, they embraced lots of American traditions, such as celebrating Thanksgiving, and, you know, maybe put their own spin on it from their own backgrounds. But you know, I feel very fortunate to have grown up in such a warm and nurturing environment with so many wonderful people.
Excellent. 3 quick questions so that we can put a cap on your college writings. Number 1, do you still hold the same views that you expressed in those college writings as you do today?
No, and I regret some of the language that I used.
Number 2, will you allow your personal opinions to influence your ability to apply the law and the Constitution as written?
No.
Number 3, will you fairly apply the law for every party who appears in your court, regardless of their gender, race, ethnicity, or religion?
Yes, of course.
All right, thank you. I want to move on to congressional power and some of your recent writings. Last year, you published an article about congressional power in the administrative state, and there's a fear that representative lawmaking is being displaced by agency regulation. This is something that concerns me. And you wrote, and I'm quoting you, Congress currently stands in the shadow of the administrative state. And you supplied suggestions on how Congress could fix its fading role. And what are your views on how Congress could reassert its lawmaking power and oversight authority?
Mm-hmm. Well, I do think that is a difficult question, and it's one I have addressed in my academic writings, as you mentioned. Some of the options are less delegation to executive agencies, more lawmaking by Congress. You know, political scientists have thought about other structural changes, but the main point of my article was really to argue about how important it was for Congress to exercise its lawmaking responsibilities. You know, it's a crucial part of our constitutional democracy that lawmaking be done by people who are democratically elected.
You have presided over a period of deregulation, and Tennesseans talk a lot about how pleased they are to get some of the regulatory burden off their back. So from where you have been sitting, what would you say is your primary contribution to pushing forward with deregulation and seeing the economic growth that we are now seeing in our country?
Well, thank you for that question. I think one of the things we've been most focusing on is moving forward with regulatory reform in a way that gets government out of the way where it's not working. There are a lot of regulations on the books that don't have the effects that were intended, a lot of paperwork burdens, and we're looking to pull back the things that are no longer working, and I think we've enjoyed quite a measure of success for that in terms of helping individuals and small businesses and families.
Thank you. My time's expired.
Senator Booker.
Thank you, Mr. Chairman. Hi, Ms. Rao. During your time overseeing the Trump administration Department of Housing and Urban Development, you've tried to roll back important protections against housing discrimination on the basis of race. One of these protections was about the agency's disparate impact standard for housing discrimination. Disparate impact, as you know, is not a novel concept. It was established government policy. It's established Supreme Court precedent. That businesses can be held liable under the Fair Housing Act for housing and lending practices that have a disparate effect. But under your watch, the department is trying to roll back this basic protection. And I'm wondering, you're overseeing the agency rule changes in this administration. Why would the administration want to undo such well-established policy and Supreme Court precedents when it comes to remedying housing discrimination based on race, going all the way back to a period of the civil rights movement and Martin Luther King, who you talked about, who you admire?
If I could just take a step back on this housing and urban development rule, the agency put forth an advance notice of proposed rulemaking last summer, which was in part designed.
I know the procedures. I'm just really wondering.
Well, it was there's some hard questions there, and as you know, there was a Supreme Court decision in 2015 that addressed this issue, and so the advance notice of proposed rulemaking was designed to tee up a series of questions for the public about whether the disparate impact standard should be changed, and if so, how. And I think maybe either we've just received, I think at OIRA, the proposed rule that's based on that advance notice of rule.
But I guess the issue for me is that this terrible experience of housing discrimination, my family even faced it itself, getting rid of this protection for disparate impact housing claims will actually make it harder to ensure the promise of the Fair Housing Act, harder to stop discrimination. And so do you understand that getting rid of this well-established protection would actually endanger our ability to hold people accountable for civil rights violations?
Well, Senator, I certainly understand that concern, but the proposed rule hasn't even been made public. So, the Secretary Carson is working on addressing that issue, and I think we need to see what the rule ultimately says. But it's under review, so I can't comment on the substance of it.
In a 2008 article, you criticized the Supreme Court's landmark decision in Lawrence v. Texas, which invalidated the state laws that criminalize same-sex relationships. You said that the court's decision, quote, eschews older traditions in favor of an emerging awareness of the meaning of and the scope of liberty. What, in your view, should the Supreme Court have been in the business of upholding older traditions, as you said, of laws that criminalize same-sex relationships?
Well, Senator, those were some comments made in the course of an article about dignity and constitutional law, and of course, Lawrence is a precedent of the Supreme Court, which I would faithfully follow if I were.
Are gay relationships, in your opinion, immoral?
Senator, I'm not sure the relevance of that to
I think relevant your opinion. If you think African American relationships are immoral, do you think gay relationships are immoral? Do you personally believe that gay relations?
No, I do not.
You do not believe that?
No.
Do you believe they're a sin?
Senator, my personal views on any of these subjects are things I would put to one side, and I would faithfully follow.
So you're not willing to say here that whether you believe it is sinful for two men to be married. You're not willing to comment on that?
Senator, no.
Excuse me?
I'm sorry?
I didn't hear your response.
My response is that these personal views are ones that I would put to one side. Whatever my personal views are on this subject, I would faithfully follow the precedents of the Supreme Court.
In the excuse me for interrupting, I have 1 minute left. In 2013 article, you also criticized the Supreme Court's landmark decision in the United States versus Windsor, which struck down the provision of DOMA that defined marriage as only between a man and a woman. You said the court had found, quote, a novel constitutional right of two people's freedom to marry and to recognize same-sex marriages. And you said that the court's decision amounted to a political choice, not a judicial choice. What do you believe the Supreme Court's decision to respect the status of a same-sex marriage, how was that a political choice and not a judicial one?
Well, Senator, in that particular article, what I was saying is that in the case in Windsor, did not recognize same-sex marriage as a right. It only recognized the right to have your marriage recognized if the state provided such a marriage. Of course, that later step was taken in Obergefell, but Windsor, part of what I was explaining was that it was a rather empty right that was in that case.
And you know, LGBTQ Americans have faced a long history of discrimination, long histories of violence, intimidation, bullying. Young LGBTQ youth in America report not going to school because of fear for their own safety at rates that are unconscionable. And a lot of the hard-won provisions that we're talking about became the law of the land very recently. So why is this administration currently trying to do so much to roll back transgender right protections and the like? And these matters could very much be brought before you under the regulatory conception that somehow protecting American citizens is burdensome.
You know, Senator, I think, you know, civil rights and equal protection of the laws are two essential values in our system. And if I were to be confirmed as a judge, I would firmly uphold that.
Have you ever had an LGBTQ law clerk?
I've not been a judge, so I don't have any law clerks.
Sorry, someone working for you.
I'm to be honest, I don't know the sexual orientation of my staff. So I take people as they come, you know, irrespective of their race, ethnicity, sexual orientation. I treat people as individuals. Those are the values that I grew up with, you know, and those are the values I would apply if confirmed.
Thank you, Mr. Chairman.
Senator Cruz.
Thank you, Mr. Chairman. The Senate Judiciary Committee should not be a theater for mischaracterizing or twisting nominees' records or views, nor should it be an avenue for persecution. You know, we've seen a growing pattern among Senate Democrats of hostility to religious faith. I have to say I was deeply troubled a few minutes ago to hear questioning of a nominee asking your personal views on what is sinful. In my view, that has no business in this committee. Article 6 of the Constitution says there should be no religious test for any public office. We have also seen Senate Democrats attack what they've characterized as religious dogma. We've seen Senate Democrats attack nominees for their own personal views on salvation. I don't believe this is a theological court of inquisition. I think the proper avenue for investigation of this committee is a nominee's record. So, Ms. Rao, let me talk about your record, and let me ask you about your actual record, which is what this committee should be looking at, not our own personal religious views or your religious views, whatever they may be. You shared at your confirmation hearing your family story about how your parents left India, arrived in Detroit in the middle of a snowstorm without winter jackets and with just $16 and the optimism of the recently married. That is a story that resonates with me. It has similarities to my own father's story. Can you share with this committee a bit of your family story and how that has impacted your life journey?
Sure. You know, my parents, as I said, came from India in the early 70s, and they had their medical degrees, and they, you know, had residencies and fellowships. They worked really hard for not very much pay. You know, I was born in 1973 when my parents still didn't have very much, but You know, I had a really happy childhood. My parents were warm and loving, and I grew up with many warm and loving family friends. And I think they conveyed many of the values that they brought with them, you know, about hard work and honesty, and that has been a big part of shaping who I am today.
Much of the questioning from this committee has also focused on your college writings, and there has been language and characterizations that I think are false and distorting. So I want anyone listening at home to be unequivocally clear. When it comes to sexual assault and rape, both are wrong, are evil, are criminal, and should be prosecuted. Do you agree with that?
Yes.
As I sat here listening to the questioning and what was being described by Democratic members, I thought, what crazy thing must she have written in college? And I pulled out and read it sitting here. And I read, for example, in one of the articles entitled Shades of Gray, that you wrote, clearly, if the male student forced the woman to have sex against her will, then he should be held responsible. You also said a man who rapes a drunk girl should be prosecuted. Now, both of those statements are unequivocally true, correct, and you said them then. What is causing Democratic umbrage is you also said that college students should refrain from drinking to excess. Now, I would note that is very good advice for a college student, whether male or female. I have 2 daughters. Now, fortunately, they're 8 and 10. We're not dealing with this yet, but I certainly intend to give them the advice not to drink to excess. And it is unquestionably true that any college student that drinks to the point of getting drunk and losing control risks being a victim, risks being vulnerable. When I was a student in college, I recall a student who was there with me who drank to excess and then tragically got on top of a train and electrocuted himself, lost 3 of his limbs. It was horrific. And so that is very good advice for a college student. Don't drink to the point of losing self-control. And I just want anyone watching this to be clear that you were unequivocal then and unequivocal now that anyone who commits a crime of sexual violence should be prosecuted. Is that correct?
That is correct.
The D.C. Circuit's caseload involves a great deal of administrative law questions, often very complicated administrative law questions. What in your professional background do you believe has prepared you to be a D.C. Circuit judge?
Yes, thank you, Senator Cruz. I believe that much of my practical and academic experience relates very closely to the specialized docket of the D.C. Circuit. As has been mentioned, I've worked in all 3 branches of the federal government. I'm currently the administrator of OIRA, where I oversee regulatory policy from different executive branch agencies and look closely at whether those regulations are consistent with law and whether they meet certain analytical standards. And as a scholar for over a decade, I've been writing about these types of issues and constitutional law and administrative law, separation of powers.
Let me ask one final question, just because I'm at the end of my time. Why, in your judgment, does separation of powers and federalism matter? Why should the people care about separation of power and federalism, 2 important structural restraints in our Constitution?
I think those structural restraints are essential to the protection of individual liberty, and our founders created that structure to protect individuals from government overreaching and tyranny.
Thank you.
Mr. Chairman, just a point of clarification, because Senator Cruz invoked my commentary, and and he knows this because we're friends. I would defend, die for, to protect the ideals of religious freedom in our country, and I was no way trying to attack the nominee's religious freedom. I was simply saying that discrimination under any standpoints, whether it's against someone's religion, someone's race, someone's sexual orientation, should not be tolerated. And the Senator and I both know that religion was used as a ruse to discriminate against African Americans. My parents told me stories that they felt it was religiously objectionable that blacks and whites should go to school together or sit down together. And so while he and I agree on the defense of religious freedom, I also know that he and I agree on the fact that no one should face discrimination in this country and when it comes to their race, religion, or even their orientation. Thank you for that moment to clarify. Thank you, Senator Cruz.
Thank you. I think end of round 1, we have Coons. I'm sorry. Sorry, Chris.
Thank you, Mr. Chairman.
Apologize.
Thank you, Mr. Chairman. Ms. Rao, there's been a great deal of discussion about your college writings, which I would agree are, at the very least, cringeworthy and have deserved and gotten a great deal of attention. I want to submit for the record, if I could, Mr. Chairman, a letter from 54 South Asian American women who are civil rights attorneys, who are law professors, who are advocates for survivors. It at length challenges some of the assumptions in your college writings. But that's not what I want to focus on today. I want to focus not on things you wrote decades ago, but your view of executive power, and in particular the unitary executive theory, and how, not in college, in the heated exchange of campus politics, not even as a law student or law clerk, but after completing all of your legal training as a professor, I think at the time, you wrote a law review article in 2014. Where you talk really very pointedly about your sense of the scope and reach of presidential power. Briefly, I'll quote, "The president must have the ability to remove all executive branch officers at will," and then you go on to explain just how broad you think that power is. Let me just put a point on this. Do you believe the president can fire at will a federal prosecutor who's investigating him, his family, his campaign team, his senior advisors? Do you think the executive power goes that far?
Well, Senator Coons, in that article, I was writing primarily about the president's control over civil cases, over the administrative state and administrative agencies. You know, the question of removal power in that context is not one I have written about or looked at closely.
Well, I appreciate that answer, but it doesn't strike me as really answering my question. You may have there been speaking to civil, not criminal, but the force and clarity with which you assert the reach of executive power overall, even including independent agencies, strikes me. To quote from that same law review article, "The Supreme Court has repeatedly recognized all agencies, including the independent ones, are part of the executive branch." You go on, "The president alone possesses the power to direct, control, and supervise inferior officers or agencies who seek to exercise discretionary executive power." Wouldn't the special counsel be part of the executive branch?
Well, Senator, respectfully, that is, an ongoing matter of political controversy and also could potentially lead to lawsuits. And as a judicial nominee, it wouldn't be appropriate for me to comment on those issues.
So is it your view that Congress can't place any restrictions, even ones that put in statute what are currently regulations that protect a special counsel from removal by the president?
Senator, I did not argue that in my articles. I did not.
Would that not seem an obvious and logical conclusion from a view forcefully and repeatedly asserted that the president should be able to remove even the heads of independent agencies?
Well, Senator, one of the things that I try to explain in that article is that there are competing interests, right? Congress has a lot of important authorities under Article 1 to create agencies and to set their powers, to set their different authorities, and that has to be balanced against the president's responsibility for overseeing the executive branch, and so that I recognize in the article Congress's important interests in those areas.
Well, and I was going to call him Professor Lee. Senator Lee, my colleague, previously questioned you about whether or not tyranny results from an overreaching administrative state. I would posit that an equal and comparably valid concern is the tyranny that might result from an overreaching executive, something I think was much more at issue in our founding. Let me just briefly turn to Morrison v. Olson, a Supreme Court case from 1988 with which I'm sure you're familiar, where Justice Scalia, in a single dissent, expounded this unitary executive theory, which has gained credence and followers. You may be at the head of that pack in the decade since it was handed down. Would you agree with me that your theory of unfettered removal power, expounded in that 2014 law review article, was expressly rejected by the Supreme Court majority in Morrison? Is that not clearly the holding of the case?
Well, I think that yes, Morrison v. Olson does recognize, some important limitations on the president's removal power.
And is Morrison still good law?
It has not been overruled, so it is a binding precedent of the Supreme Court, which I would follow if I were confirmed.
What's the view of the D.C. Circuit of Morrison?
The D.C. Circuit has upheld the validity and recognized that it is still good precedent.
How recently?
I think quite recently.
Quite recently, I think, in fact, last year. And so I'm troubled, I have to say, not just by that 2014 law review article, but by a 2011 law review article where you're going through Free Enterprise Fund versus PCLOB and suggest, and I quote, that Supreme Court opinion strongly suggests statutory limits on the president's removal power, such as those protecting the officers of independent agencies, are unconstitutional. Let me make sure I get this right. Do you believe that the Constitution allows the president to fire, for example, the chairman of the Federal Reserve whenever he wants, even to influence monetary policy for his own personal or political benefit?
Well, Senator, again, those questions are ones that depend in part on the particular statute at issue and the types of protections it provides. And those were comments I made as an academic commentator and scholar, where I was able to write about the law in the abstract. And I very much understand that it's a completely different role when one becomes a judge and needs to decide specific cases and controversies according to the law and precedents.
Well, Ms. Rao, I think, alarming writings in college aside, I think very recently in law review articles, you've laid out clearly and forcefully a view of executive power so overreaching and so outside the mainstream as to be truly alarming to me in terms of its potential consequences for the scope and reach of executive control and executive power. And while I respect your refusal to answer directly, given some of these things are current controversies, I also have to say, in the context we currently find ourselves in, these are no longer merely academic questions. Thank you, Mr. Chairman.
Thank you, Senator Coons. Now we've finished the first round. I'm going to have to depart at 12:15. Senator Blackburn, I think, is going to chair after that, and I appreciate that more than you know. We've had Senator Feinstein, Blumenthal, Hirano, Whitehouse, and Kennedy request second rounds. So we'll do 5 minutes, second rounds, and we'll get started. Let's start with Senator Feinstein.
Mr. Chairman, Ms. Rao, as I sit here and listen, let me tell you what the heart of my concern is. And it goes back to my question, which is on recusal. It's my understanding that you have led the Trump administration's regulatory agenda. You've worked on repealing the Clean Power Plan regulation, repealing protections that address pay discrimination on the basis of race, and weakening the CAFE standards that I spoke about. Let me tell you how one of your predecessors before this committee responded, and that's Mr. Katsas. He was asked the same question, and he said, if I were confirmed, I would look carefully at the standards for recusal. That was your answer. But what he said was, I can commit to recusing myself from any case that I worked on while in the executive branch, any challenge to presidential or agency action on which I have provided advice. That's the answer that I look for, that you go in as a fresh human being without the bias of a prior workplace and use the talents that you have acquired in a way that only relates to the case before you and its rightness or wrongness legally. And you won't make that direct commitment. I want to give you another opportunity to speak in hopes that you will make that direct commitment. And that is that you will recuse yourself from any case that involves something that you worked on as an executive in this administration.
As I have said, I think recusal is a very important issue, and it's one I would take seriously. The question of recusal is often very fact-specific. It depends on the type of case that's brought. I currently oversee regulatory policy, which are generally applicable rules. It's somewhat different than a lawyer working in the White House counsel's office providing legal advice. So again, I commit to you that I would follow the statutory standards. I would talk to my colleagues and follow the approach that they have used, and I would strive to be impartial and independent in all the cases I decide.
Well, let me just sum that up. What it says to me, in areas that I care very much about, that have to do with environmental protection as well as other things, you would not be a positive vote. That's how this comes through to me, because you have worked as an executive, and unlike people that have come before us for this court, they have said, yes, I will recuse myself. You're not saying that. So I take if you don't say it, I assume you will not recuse yourself. With all the mumbo jumbo that you answer the question with, the question is, will you recuse yourself? And you will not say yes.
I have not said yes. I will not say no. It's something that I'll consider in each case as it comes. And I think that it's important to take that seriously, you know, when cases come before me, if I'm fortunate enough to be confirmed.
Thank you, Mr. Chairman.
Thank you. Senator Kennedy.
Professor, clear something up for me. My esteemed colleague, Senator Feinstein, talked about how you'll vote and not vote. You don't know how you're going to vote yet, do you?
I certainly do not. And in every case that comes before me, I carefully consider the law and the arguments of the parties and decide cases according to the law.
Okay. Your parents immigrated here from India, is that right, Professor?
That's correct.
Okay. Have you ever been a victim of racial discrimination?
Yes, Senator, I think there are times where I believe I've been treated differently on the basis of my race. It's not a great feeling.
Did it happen when you were younger, or does it happen when you were an adult?
You know, it's hard to say. You know, it certainly happened when I was younger. I think we lived in a different time. You know, but my parents also faced different forms of discrimination, you know, in the workplace. And, you know, I remember them telling me, you know, they went to go eat at a restaurant, you know, once when they were on a road trip, and they were told, you know, this was in the early 70s, they were told, you know, you can't eat in the dining room, but we'll put a table for you here out in the hallway. You know, so those are things that are you know, part of the stories I grew up with, but I was also encouraged to focus on the positive, right? All the great things in this country, and all the opportunities for advancement, and all the good people who you know, who helped my parents along the way. So that was really what I was taught to focus on.
Do you think our society has gotten better in terms of appreciating ethnic diversity?
Well, I certainly hope so.
Yeah. Do you think I'm just curious, do you think it's possible to be racially insensitive without being a racist? I'm not trying to trick you, I'm just want to know your thoughts.
Perhaps, yes.
Yeah.
You know, I think sometimes people lack exposure to different groups, you know, so there's sometimes a lack of understanding of differences.
I want to shift gears a second. Can you tell me the difference between an originalist and a textualist?
Well, Senator, I think originalists look at the text of the Constitution, of course, and then look to see what the original public meaning of those words were at the time the provision of the Constitution was enacted.
Okay, and by public meaning, you mean, what do you mean? Do you mean the drafters or the average citizen at that time in our country?
Well, I think, you know, I think it's usually meant to be a reasonable observer, you know, who was sort of paying attention and involved in thinking about these issues, so kind of a reasonable, objective observer at the time.
At that time, let's say in the late 1700s?
Yes, at that time.
As opposed, and so, are you an originalist?
You know, Senator, I try not to put labels on myself in terms of judicial philosophy. You know, if I've been nominated to a court of appeals, I would certainly follow the precedents of the Supreme Court, which often look at the original public meaning of constitutional provisions.
If an originalist interprets the Constitution based on the public meaning, as you put it, or the meaning to the average person at the time the Constitution was adopted, do you think the average person at that time, that when the Constitution was adopted, believed in, I don't know, desegregated schools?
Senator, it's not necessarily what they intended, the words would have meant. It's what those words could fairly be taken to mean. So for in the context of the 14th Amendment, the drafters of that used the very broad language of equal protection of the laws, which, regardless of what their intentions were, they use this very sweeping language, which has been a tremendous promise.
But this is what troubles me. I'm not saying I disagree with it. I'm just seeing how you reconcile it in your mind. We're supposed to, if you're an originalist, you interpret the Constitution as understood by the average American at that time, right? Okay? Do you believe that the average American at that time believed in integrated schools?
I don't know. They may not have, but they may have had an understanding of the meaning of the word equality,
right,
which was to treat people the same, even if they did not believe that segregated schools was a violation of equality. They would have had an understanding that equal means treating people the same, and that promise has been carried forward in our history in a series of important cases by the Supreme Court.
That was good. Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman, and thanks for the second round. I want to come back to this idea of the unitary executive theory and what you've said and written about it, because I think it is an issue of paramount importance at this moment in our history, and I am deeply disturbed by views that certainly create the impression of your belief in an imperial presidency, to use the colloquial term. Not a law review article, but an interview you did with Hugh Hewitt, December 15th, 2017, just a little more than a year ago. He asked you about the authority of the president to direct or fire the Attorney General or the Deputy Attorney General or the Special Counsel. And he said, everybody who is not an independent agency answers to the President, and therefore the President can direct them how to act. Can he not? Your response, that is certainly true. Do you believe that the President can fire Robert Mueller, Special Counsel, or direct the Attorney General to fire him?
Well, Senator Blumenthal, the context of those comments, again, were in the administrative context, the civil context of administrative agencies.
Well, he was referring to the Special Counsel.
Well, I was on that show to talk about regulatory reform, and that question came up. But the question you've posed is one that
Let
is,
me
of
ask
course,
you, as you sit here, do you believe that the President of the United States can fire the Special Counsel or direct the Attorney General to fire him?
Well, Senator, those are questions that are in active political debate and may well come before me if I were to be confirmed as a judge, and so it would not be appropriate for me to comment on them.
Well, I know that you've been reminded of your comment about, and I'm quoting, senators ask important but highly predictable questions, and the nominee is coached to choose from certain stock answers. And I know you're giving a stock answer, but let me ask you then, in light of your past comments, would you recuse yourself from that question if it came before your court, since you've already expressed your views on it?
Senator, I'm not sure that I have expressed my views on that subject respectfully, and again, I would take recusal seriously and again apply the statutory and other standards that are relevant there.
Let me move to another topic. Do you believe Brown versus Board of Education was correctly decided?
Well, Senator, Brown is a really important precedent of the Supreme Court, and one that overturned Plessy versus Ferguson, which was a real black mark in our history.
So you believe it was correctly decided?
Senator, as a judicial nominee, I think it's not appropriate for me to comment on the correctness of particular precedents. I would faithfully follow them if I'm confirmed.
Do you believe that Griswold versus Connecticut was correctly decided?
Again, Senator, that's a precedent of the Supreme Court, which I would follow.
How about Roe v. Wade?
The same thing. It's a longstanding precedent in the Supreme Court, which I would follow if confirmed.
Well, you know, I am struck by someone who has said that you were a victim of discrimination, very unjustly and unjustifiably, and yet you're unwilling to say that Brown versus Board of Education was correctly decided?
It's an incredibly important decision of the Supreme Court, but again, it's just.
Well, Plessy versus Ferguson was a very important decision of the Supreme Court, but it was wrong.
And it was overruled by Brown.
So that's why I'm giving you the opportunity to tell us you think Brown versus Board of Education was correctly decided.
It's an important and long-standing precedent of the Supreme Court, which
and so it could be overruled too.
Senator, it's hard for me to imagine any circumstance in which Brown versus Board would be overruled by the Supreme Court.
It's hard to imagine, but I'm asking you to state that you believe it was correctly decided.
Again, Senator, you know, it's a very important precedent of the Supreme Court.
Thank you very much, Mr. Chairman.
Senator Hirano, you're recognized.
Thank you. Senator Coons submitted for the record a letter from the South Asian American Women group, who are civil and human rights lawyers, law professors, and advocates of survivors of violence, some of whom I believe are in the audience today. And that number has grown from 54 that Senator Coons mentioned to 65 signatories. And I would like to read from a part of their letter. I'm quoting in their letter: "We firmly believe in the importance of a diverse federal judiciary, and it is not lost upon us that if confirmed, Naomi Rao would be the first South Asian American woman to sit on a federal appellate court. However, we are deeply alarmed by Naomi Rao's record, particularly around gender rights, and we do not believe that she will bring independence and fairness to the federal bench." End quote. Ms. Rao, in 2017, you claimed that in fiscal year 2017, the administration had taken 860 deregulatory actions and withdrew or delayed more than 1,500 planned rules. For fiscal year 2018, you proudly said the administration's deregulatory actions, quoting you, saved American families and businesses $23 billion. As OIRA administrator, you noted that the administration is considering lowering the CAFE standards and the vehicle emission standards. Will lowering these standards save businesses money?
You know, Senator, there are a number of costs and benefits to that proposed rule, which have been noted by the agencies, and it's a very complex regulatory scheme.
Well, you said that all of these regulatory decisions, the previous regulatory decisions, and the one that you're contemplating, saved a lot of money. I would say that lowering the caffeine standards would save businesses money. Next question. The administration is also trying to loosen greenhouse gas emission limits from power plants. Will loosening these standards save businesses money?
Senator, when agencies propose regulations, they look at a whole range of costs and benefits, and the idea is to put forward regulations, whether they're regulatory or deregulatory, that have net benefits for the public. So, you know, in this administration, when we're pulling back regulations, that's when pulling back the regulation will have more benefits to the American people than costs.
Well, you obviously have information on the cost savings to businesses. So, going back to the $23 billion you mentioned, how much of that $23 billion was money saved by businesses versus families?
You know, Senator, we don't necessarily calculate it that way, but a lot of the beneficiaries of regulatory reform have been small businesses, small fishermen, farmers, and individuals. So, you know, there are a range of benefits that extend over wide swaths of the.
So, since I assumed that you had a factual basis for the $23 billion, would you be willing to submit to this committee, or certainly to me, a breakdown of who saved $23 billion that you mentioned?
Well, Senator, we've tried to be very transparent about how we've calculated this. There is probably more information than you'd like on our website about how those numbers were calculated, which rules.
So your
resulted
website
from.
will enable me to determine how much of the $23 billion was saved by businesses, whether large or small, versus families.
Well, I think yes, going to the underlying rules will give you some of that information.
I want to get to LGBTQ rights. As a lawyer, you wrote negatively about 2 Supreme Court decisions that affirmed the rights of LGBTQ individuals. In 2008, you criticized Lawrence v. Texas, where the Supreme Court invalidated Texas sodomy law for ignoring traditional constitutional analysis. In 2013, you argued that the U.S. v. Windsor, which struck down the Defense of Marriage Act, was effectively a political choice to, quote you, favor recognition of one group's claims over another. And under your watch as OIRA administrator, the Trump administration has sought to reverse regulatory protections for LGBTQ individuals in schools, the military, and in healthcare. So there is ample evidence that you have a consistent pattern of, with regard to the rights of LGBTQ individuals and protections for them. So what evidence is there that LGBTQ litigants can trust that you will fully follow Supreme Court precedent protecting their rights instead of chipping away at them based on your prior expressed views? And I realize that there's some Supreme Court precedents and you can apply them, but you know, just as in Roe v. Wade, which I doubt will be not overturned, those protections are being chipped away. So, you know, what kind of reassurance can you give to LGBTQ litigants that you can view their rights in any lawsuits that involve them in a way that will protect those rights?
Well, Senator, I think it's very important to respect the equal dignity of all individuals. And if I were to be confirmed, I would work to uphold the equal protection of the laws and faithfully follow the precedents of the Supreme Court.
Thank you.
Gentlelady's time has expired. Ms. Rao, we thank you for being with us today and for sitting through all the questioning. And thank you for your service to our country and for your desire to serve our nation. I can say for me, I look forward to voting for you. And we thank you for your time today, and you are dismissed from the committee. We will stand in a momentary recess while we reset the table.
Thank you very much.
The committee will reconvene, and we welcome before us Professor Adite Bamzai. Am I saying that properly?
That's correct, Senator.
Thank you, and Mr. Travis LeBlanc. And Professor Bamzai to be a member of the Privacy and Civil Liberties Oversight Board, and Mr. LeBlanc also to be a member of the Privacy and Civil Liberties Oversight Board. And I thank you all for your willingness to serve and for the excellent resumes that you bring to your desire for public service. At this time, I want to ask each of you to stand and be sworn in. Do you affirm that the testimony you are about to give before the committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. At this time, Professor Bamzai will begin with you for your brief opening and introduction.
Thank you, Senator Blackburn, Ranking Member Feinstein, and members of the committee. Thank you for your consideration and your time. It's an honor to be nominated to be a member of the Privacy and Civil Liberties Oversight Board. Preserving appropriate checks and balances in our effort to protect the nation's security is one of the central challenges of our time. The board plays a key role in helping to ensure that the anti-terrorism efforts of law enforcement and intelligence agencies are consistent with the protection of privacy and civil liberties. In the past, in my own career, I've had the opportunity to work on such issues as an attorney in the Department of Justice in 2 administrations of different political parties. If confirmed as a member of the board, I hope to bring that background and expertise to bear on the challenging and technical issues that the board confronts. I am committed to approaching the board's work in an independent, nonpartisan, and objective fashion. I'd like to thank my wife and 2 children who could not be here, and my father and my mother. My mother sits behind me. 28 years ago, my parents packed our belongings into suitcases and moved us from another country to a motel not too far from here at the intersection of routes 236 and 50 in Virginia. Quite literally, I would not be here today but for their courage, guidance, and sacrifices. Thanks again for considering my nomination.
Mr. LeBlanc, you're recognized.
Senator Blackburn, Ranking Member Feinstein, and members of the committee, thank you for your consideration. It is an honor and privilege to be nominated to the Privacy and Civil Liberties Oversight Board. I would not be here today without the support of my family, friends, teachers, mentors, and colleagues. It is not lost on me this morning that, if confirmed, Aditya and I would be the first people of color presidentially appointed to the board. I am therefore grateful to the many giants throughout our shared history who have knocked down the barriers that make it possible for me to be here today before all of you. While I cannot acknowledge all of those who have made it possible for me to be here, I would like to specially recognize a few people. First is Senator Harris, for whom I had the honor of serving with when she was the Attorney General of the great state of California. Everything I cherish about serving the people I learned from Senator Harris. She ensured that we approached our work as prosecutors with decency, compassion, and a sense of purpose. And every day that I wake up yearning to make our world a better place, I am reminded of and inspired by the spirit, dedication, and courage of Senator Harris. While my professional relationships are special, my familial bonds are divine. I would be remiss if I did not express my profound gratitude to my life partner and our 4-year-old daughter who are here with me today, as well as my mother, Therrell, brother, Brandon, and all my family watching from my home in the Southland's fairest city, New Orleans. Senator Blackburn, if I may take a point of personal privilege, I also feel compelled today to acknowledge the New Orleans Saints, who many believe were wrongfully denied a Super Bowl appearance on Sunday. I don't pretend to suggest that the Privacy and Civil Liberties Oversight Board has any jurisdiction over the National Football League. But if I learned anything from the NFC Championship game this year, it's that those people who are charged with enforcing the rules sometimes need the advice and oversight of independent observers. The Privacy and Civil Liberties Oversight Board is just such an independent advisor and observer. The board is charged with balancing the government's efforts to protect terrorism with the need to protect privacy and civil liberties. As we all know, these are dangerous times. The threats posed to America by its enemies, both foreign and domestic, are very real, and they are very serious. At the same time, however, the failure to consider the implications of our security policies on privacy and civil liberties may itself threaten our nation's security. The PCLOB's twin functions, oversight and advice, reflect the wise judgment of Congress about how to best balance security and privacy in the modern world. If I am fortunate enough to be confirmed as a member of the PCLOB, I will bring an independent and open mind to the board. I will seek the views of all stakeholders. I will work tirelessly to ensure that my work reflects rigorous and thorough consideration of all information available to me, and I pledge that I will embody the bipartisan spirit of the PCLOB. As this committee knows, security, privacy, and civil liberties are American issues, not partisan ones. Thank you for your time today.
Thank you, Mr. LeBlanc. Professor Bamzai, I want to start with you and discuss China and some of the concerns that we have with China as they have really sought to disadvantage American companies. They've stolen technology. There is a lot of piracy that we deal with. I've got a lot of entertainers and innovators in Nashville that are dealing with them regularly. And last month, the Justice Department really unleashed some indictments on Chinese telecom maker Huawei, who some of us have followed some of their actions and misdeeds for years, and went after them for stealing some of the trade secrets from T-Mobile. Right now, we are demanding extradition of a Huawei executive to stand trial. President Trump is encouraging other countries to block Huawei from supplying some of the 5G equipment that is coming into the marketplace. And he's doing this because of security risk. So what do these criminal indictments foreshadow about the threats Chinese tech and telecom companies pose to American security?
Senator Blackburn, thank you for the question. So I'm aware of the episodes that you've narrated just over the last few moments from the news and other sources of that nature. Of course, the government itself has more information on these types of issues, and if I were lucky enough to be confirmed to the board along with my fellow board members, I would look to see how the Privacy and Civil Liberties Oversight Board could bring its expertise to bear on the types of issues where we would be most useful to both the intelligence community in this chamber, the Congress generally, and the American public. And I'd be happy to take those types of considerations, this issue, into account during my service on the board.
Excellent. Okay. Mr. LeBlanc, the big tech and their privacy violations compound every single day. There is a news story nearly every day. Last week, Apple temporarily banned Facebook and Google from distributing apps that violated Apple's privacy guidelines. Facebook apps targeted children as young as 13, luring them through Instagram and Snapchat ads, offering $20 to have access to their iPhone data. The app allowed Facebook to track the user's app history, private messages, location data. And as a mom and a grandmother, I tell you what, some of these privacy violations to me are so offensive. And I do see them as a threat to our children and their security. But let me ask you this. You've got a precious daughter who is here with you today. And what other precautions should be in place to protect consumers, both young and old, from falling victim to some of these privacy violations?
Thank you very much for that question, Senator. I am very well and have followed your own work in the House when you were working on issues around privacy and emerging technologies and social media. In my view, one of the biggest challenges that we face in the United States right now is that we don't have baseline federal privacy legislation. It does appear as if there is a desire right now across industry, across consumer groups, across federal and state governments, as well as across party lines, for some kind of protections to be put in place as a matter of law. If, in my view, for my daughter's sake, for the sake of the future, I think that having some common baseline federal privacy legislation would be helpful there. I am mindful, however, that the jurisdiction of the Privacy and Civil Liberties Oversight Board is limited in the role that we have with respect to protecting the privacy of the people. I will work with my fellow board members to ensure that we can take every step within our power to maintain the balance between protecting security and also ensuring the privacy and civil liberties of the people.
Would you take the same approach to data security? Because data breaches since 2013 have been rampant and have affected millions of Americans. You look at just last year when you had Dunkin' Donuts and Under Armour and Marriott hotels and information that was out there and the need for some data. Do you back the need for data security legislation and breach notification preemption?
It's a very good question. I will start by saying it's a bit outside of the jurisdiction of the Privacy and Civil Liberties Oversight Board. I am pleased that 50 states in the United States now have data breach notification laws. The question of whether or not there should also be a federal one is one that's left to the wise judgment of Congress at this point to decide on that. But there is no doubt that the number of breaches have gone up over the last few years. The breaches themselves are getting bigger. And at the end of the day, a large number of these seem to be resulting from foreign nation states that are attacking American companies and American individuals. I think it's important and it would be good for us as a society to begin to examine what protections we can also help put in place to protect American businesses and individuals from foreign nation states engaging in cyber attacks on them.
Thank you. Senator Feinstein.
Thanks very much, Madam Chairman. Welcome, gentlemen. I'm going to ask one question. 3 provisions of the Foreign Intelligence Surveillance Act, the lone wolf provision, roving wiretaps, and certain expansions of what's called the business records provisions are scheduled to sunset on December 15th of 2019. I've sat and been chairman and vice chairman of the Senate Intelligence Committee. These are important provisions. The board you're going on, which we call the PCLOB, has often been very helpful in providing advice to the committee. Have you taken a look at these 3 issues? We are expected, the Congress is, to consider an extension of some or all of these 3 provisions next year. If you have thoughts, would you express them? If you don't, would you look into that?
Senator Feinstein,
go ahead.
it's a very important issue, and I think I'm very familiar with this set of considerations from the USA Freedom Act that was enacted in 2015, which is due now to sunset in 2019. And as you well know from your service on the Intelligence Committee, the propriety or even the legality of programs of this nature depend very much on the facts and circumstances. So if I were lucky enough to be confirmed, what I would want to do immediately is to provide some sort of product to the members of this body so that they could, it would helpfully inform them in the debates that are to come about the reauthorization of that bill, along with, of course, an understanding that it would be my board members and I together making those kinds of decisions. But I completely agree with you. These are very important debates.
Thank you. Mr. LeBlanc, given.
Thank you for the question, Senator Feinstein. Like Aditya, I too am familiar with these provisions. I'm also aware that the USA Freedom Act will sunset in December of this year. I don't right now have the benefit of classified information in order to evaluate whether or not these programs have been successful or not. I do pledge that if confirmed to the board, I will keep you fully and currently informed, and I do hope that along with my other board members, we would examine these issues so that we can be available to Congress as you consider this very important decision later this year.
Thank you very much. That does it for me, Madam Chairman. Thank you both for your willingness to serve. It's appreciated. Thank you.
And there being no additional members who are in the room for questions, we will remind all senators that the record will remain open until 5 o'clock on February 6th for additional questions, and we ask for your prompt response to those questions. At this time, the hearing stands adjourned.